unconstitutional.
Mention before the other bench.
It will take only 1 minute.
But I will not be here.
Oh, I see.
That is what I am saying. When mentioned before the other bench.
My lord, there happens to be a matter, my lord, in compelling circumstances that is being mentioned for the second time today. Your lord, that was mentioned earlier by Mr. Mukherjee, and it was supposed to
Which
appear.
Mukherjee?
Mr. Devjit Mukherjee. Mr. Devjit Mukherjee.
Yes.
My lord, the matter was mentioned, your lordship allowed it. The matter would take only 3 minutes, section 5 application, and for remanding the matter back to proceed with the suit.
Oh.
It won't take more than 5 or 6 minutes. But tomorrow, my lord,
Provided my existence is there, physical existence is
I
here.
can appreciate tomorrow, my lord.
So tomorrow, that's why I say my physical existence is here. I am going to hold a circuit at Andaman.
My lord,
Come
order-
after 15-20 days.
my lord, the next returnable day, whenever your lordship
After-
returns,
in the month of October, I will be back on 30th of September.
my lord, can it be that fixed on 30th?
30th is a Saturday. Will you
I mean to say the next working day.
come after that? I will consider.
Well, may I be permitted to mention one matter. That is not in this matter. This is a very substantial question of law. This is
In your matter.
this is my matter. This is state. I am for representing the state. My lord, the petitioner, my lord, here enjoying the interim order of injunction, my lord. And on the basis of that order of
mentioned before the other.
no,
bench.
my lord, I want to fix the matter so that matter can be heard by tomorrow.
We are
It
not
is
here,
assigned. It is assigned.
But I am not here.
I know. That's why
I'm
as
sorry.
soon as my lord, I'm
Sorry.
I-
Then
I-
come
my
after.
lord, my lord, let it. I want
On third.
no. Yes, my lord.
Come
I
on third.
no, my lord. Yes, my lord. Whatever. Yes, sir. Slip the DG.
May I have my lord's kind leave to mention?
My lord, kindly consider one thing, whether 2013 or control order doesn't exist or not. This is a question, pure question of law. And my lord, my lord, only as soon as my lord, let it appear. See, my lord,
Convince my brother.
no, my lord, how can I, my lord, my lord,
We are not. I am not here from tomorrow.
I know
Please
that
come,
I
please
do
come.
not want to get
Please come on third. Mention the matter. We'll
my
consider that.
thought.
Come on third. We are saying so.
That's why, my lord, sir, let it appear on third so that
No, not third.
May I
Come
have
on.
my lord's
All
kind
right,
leave
right.
to mention the specially assigned matter only for inclusion in the original side, my lord, that Calcutta Club matter.
Come after third.
I'll
oblige.
Oblige.
With the leave of Justice Vishwas, my lord. But one matter.
Leave is not granted. Let him grant the leave.
His lordship granted. One matter, your lordship had with Justice Gupta. Her matter was CAB, my lord, regarding compromise, my lord. Okay. But
Today is the date. We'll do it from on a virtual mode. Don't worry. এই গুপ্তা সাহেব তো ফোন করেছিলেন, সব রেডি আছে, তুমি গিয়ে ওখান থেকে জানলে না যে কবে দিতে হবে, কোথায় আছে? দুটো আছে, ও মেনশন করছে কিসের লিস্টে আছে ওর মামলা?
judgment is
Today there are two matters. ও আছে ওনার ম্যাটারটা দেখো। What is your matter? FA? What is the name?
Sun Construction.
Oh, not here.
It's not in the list, today's list.
We'll consider it. Yes.
No, item number 1, I am there.
For 2.
I am appearing on behalf of the appellant in item number 3.
State. So state is required.
No. For delivery of the judgment, no state is required. If they chose not to appear, then what can?
These 3 appeals therefore succeed. The order of the trial court dated 27/2/2013 is hereby set aside. Appellants, namely Sahib Das, Sandeep Ghosh, and Sukumar Kormakar, are in jail, shall now be released forthwith unless their presence is required in any other case.
Deeply obliged. Only one correction, Shondeep Ghosh was not in the custody. He was all along on bail during the course of the trial. One small correction will
They
be,
are on custody.
they are on custody. So for 2 and 3 is concerned, they are in custody. I am on bail.
We are
Just
adding
judgment.
this if they are in custody.
Deeply obliged. Deeply obliged.
Or is
The appeal is dismissed. Judgment and decree passed by the learned trial court is hereby affirmed.
Time for the appellate.
could not find any point. We do not find that the instant appeal involves substantial question of law. Appeal is dismissed. Next,
I am led by Mr. Devasis Banerjee, my lord. We have the petitioner.
we cannot overlook the fact that by virtue of Act of 37, the personal law is applicable to various forms of dissolution of marriage, and therefore the talaqul tafis, being one of the modes of dissolution of marriage, cannot be taken out of the ambit thereof. Even if Section 5 of the Act of 1937 was repealed by an Act of 39, it can at best be regarded as an additional right conferred upon the Muslim married woman to seek dissolution, and therefore the latter act cannot override or supplant the Act of 1937. The Act of 1939 is merely a consolidating and clarificatory act relating to the provisions of the Muslim law in relation to the suits for dissolution of marriage by women married under the Muslim law, and therefore has to be interpreted in such manner. The matter can be viewed from another angle. A Muslim man has a right to dissolve the marriage under any of the forms of the modes of the dissolution of marriage as recognized by law, whereas the Muslim woman shall be dragged to the court seeking a decree for dissolution despite exercising the right under the personal law. More particularly, when the husband has accepted the decision of the wife, the disparity has to be avoided, and the parity in relation to the exercise of right in relation to a dissolution of marriage is required to be upheld. In the instant case, we have said so, and then we said that it is at the nebulous stage. We do not want to interfere with the order. Tribunal to decide the matter finally.
আমাদের নামগুলো আছে তো?
Next,
Will I appear on behalf of the petitioners?
the order of the tribunal is set aside. The application filed before the tribunal stands allowed. Appeal is dismissed.
Grateful.
We thus do not find that the instant case involves a substantial question of law. Appeal is dismissed under order 41 rule. Appeal is dismissed. Yes, call.
এটা দেবেন তো?
Oh, this is that matter. Your Lordship, when you see this judgment, AIR 65 Supreme Court 1049, paragraph 11 is that representation by the legal representative, and paragraph 12 is the matter which has to be done in our case.
Paragraph 11.
11 is says, because order 22 rule 4 says to bring the legal representative, not the others. And if one of the left out, then what will happen? That is dealt in paragraph 12. So for representation is concerned, this is approved in recent judgment 2020. But wrong book has come. That is, if some of the heirs are left out, that is nothing because they are represented. This is also in 2020.
This is also in 2007. Volume 2 or 3, SCC page 123.
So for representation concern, that is 2020 is the last judgment, same thing. Not that wrong book has come. Not I can
Bring the correct book.
will also can
From
see
the
it from
library.
this one. Will also will Give the reference.
reference is AIR 2020 Supreme Court, page 740. First volume নিয়ে এসছে। First কুড়ি পর্যন্ত আছে এখানে।
Lako, AIR 2020 Supreme Court,
740.
ওইটা আনো।
There it is said that if some of the areas are left out, some of the, that nothing, because it was represented. It will bind the others. But what will happen, this second, paragraph 12,
I'm conscious of 19, this judgment, I am conscious, 65.
here he said at the time of hearing of the appeal, you add them to make the record complete. Therefore, it cannot go back.
Very interesting references here that there is no impediment on the part of the court to bring those left out here.
Yes, at the time of hearing, final hearing.
At the time is just before proceeding to complete the hearing. I lost the track. What has been held here is that the left out here should be brought on record to complete, to bring a completeness of the parties to the proceedings. But exception was carved out that this matter was pending since 1935, and for a pretty long time it continued. And the heirs who are already on record can sufficiently represent the state. And therefore, it would be absolutely idle formality, or it will delay the disposal of the matter. So the Supreme Court decided to proceed with the hearing of the matter. That if on merit, do not find there is any merit in the appeal, then no question of impleading them as a party.
And Supreme Court says that here you add them.
No, that is, it says.
Therefore, where to be added? Here the question is where to be added.
What I say is the exception which is there is that, yes, there is no impediment, you can add it. But what the Supreme Court says that will delay the disposal of the appeal. And that in that case, it was 1935 suit. The
Yes,
Supreme
that
Court
is
said no need.
what I am on.
Say there is no fetter.
Because an application for substitution was allowed by one. An application for substitution, normal case, was allowed by one court. And if it is found later on that some of the heirs were left out, but some of the prisoners were left out, it is not that order has to be recalled. That has to be, they are only added as a party. It is not necessary to recall the earlier order for substitution or recording date. That is not necessary.
But 1990 Supreme Court 2053 says differently. If any of the heir is left out, AIR 1990, that is also a 3-judge textile association matter. If I correctly remember, 1990 volume, AIR 1990 page
Paragraph
2053,
9 of this judgment,
which is
2020.
you got that book?
Yes. Paragraph 9, following 65 Supreme Court.
This is that judgment, 64. Paragraph 13.
9, on the question of representation, it is said if the some of the heirs were left out, that will also not affect the hearing of the matter. Following 65 Supreme Court. And now only the question is where to I have to make the application, whether the order of substitution or recording death has to be recalled, or I have to file a fresh application for adding them party. Supreme Court said 65, they file an application for adding them party to make the record complete. And as per our appellate side rules, it will go to the learned single bench. It is not necessary to recall the order of substitution. And in our case, recalling date of the recording date does not arise because date is already there. Who will be the representative? This is the only question. Some of them already on record. And when I find that some of the others representative are there, I file an application for addition of them. That will be heard by the single bench as per our appellate side rules.
There are others. The application will be including the which I referred, 2007.
Supreme Court 1, 2, 3 more 123 পাতা
Page number, I am sure.
1, 2, 3.
1, 2, 3, I am sure.
Volume is
Volume,
2 or 3.
I do not know. I have a doubt. Page number is correct, 1, 2, 3.
You'll
It's
logically
a 2-page, probably.
then you'll logically
2-page
make it at 2 p.m. lot.
2-page judgment or a 3-page judgment,
Or short password, but I'm coming back.
relying on another judgment of the Supreme Court in Suraya Begum's case. That was probably 1991 judgment.
You'll also make it possible for the
Suraya
sometime.
Begum,
I'm coming.
and it is referred therein and accepted by a 3-judge bench of the Supreme Court on the ground of this doctrine of representation. That if the state is represented by any one of the heirs, then if the other heirs are left out, that will not invalidate the whole thing. It
That
will
is
bind
also
the state.
2020. That is also in 2020.
That is bound in the state, any decision shall bind the non-legal representatives as well.
Yes.
If the state is sufficiently represented by some of the legal representatives.
And if there is no collusion to bringing the fraud or collusion.
Yes, fraud, collusion, or something which is available as a personal defense to those left out. There may be cases where personal defense is there.
Not only in our case, only question is where to file. I have to file the application. Whether the order allowing the substitution has to be recalled.
I got your point. I got your point. What do you say, sir?
If it has to be recalled, then there are many cases that the matter will come, and the judge who has passed the order.
Because
When the order was
this
passed,
judgment of 3-judge bench of the Supreme Court in 1965,
But I do not find that.
Is that it is only the legal representatives who are to be brought on record.
Because
Consent
order
of-
22,
Yes.
order
yes.
22 rule 4 says only legal representative, not theirs.
And legal representatives is defined in the code of civil procedure also.
The AR may be legal representative or the executor, or
No,
they are also
anybody,
maybe legal
anybody-
representative.
and also a person who intermeddles with the state is also a legal representative. So this is the legal representative is separately divided by 211. Yes, 62. Say, oh, yes, 62. So 211. State of yes. Yeah, wait. State of existence. So necessarily Dorker yes, anybody who intermeddles with the state is also regarded as person.
চিঠিকে কনেক্ট করবো।
ও বাবা ভুল ভ্রান্তি করবে না তো? The matter is listed before us at the instance of the appellant. You are the appellant.
I'm the
At the instance of the appellant. Even after The second appeal has been admitted. Because of the order dated 29/8/2022 passed by the single bench, while hearing an application being CN 73 now by hearing an application being CN 8 of 2022, wherein the single bench opined that the left out heirs and legal representative of the deceased respondent number
One.
1 cannot be added as respondent in the instant appeal unless the order allowing the order passed by the division bench allowing an application being CN 7393 of 2018 upon recording the death of the said deceased on the score that the respondent number 2 and 3 are already on record as heirs and legal representative of the said deceased, comma, is recalled by the division bench. The aforesaid application being case CAN 8 of 2022 is kept pending for such reason, and a point arose before us as to whether the aforesaid application is required to be kept in suspended animation until the order passed by the division bench allowing the earlier application upon recording the death of the respondent number 1 on the ground that the respondent number 2 and 3 being the heirs and legal representatives of the said deceased are already on record, comma, is recalled. A prelude to the incorporation of provisions relating to substitution in the court of civil procedure is required to be recapitulated before we embark our journey on the peripheral of the aforesaid point indicated herein above. The code of civil procedure was enacted to consolidate and amend the laws relating to the procedure of the court of a civil judicature which in no unequivocal terms is deals with certain substantive rights created thereunder. and the procedure to be adopted by the court in any legal proceeding. The code of procedure is divided broadly in two parts. The first relatable to various sections, creating a substantive right into the process. And the other part relates to schedule, which is procedural in nature. There's no ambiguity in our mind that the substantive part is regarded as a body of the court, and the schedule denotes the procedures to be adopted in any judicial proceedings instituted before the court, where the said codicil procedure is extended and or applicable. We are also not unmindful of a proposition of law that the procedure is a handmaid of justice and cannot be treated as a jealous mistress. Or in other words, to defeat the rights of the parties or to bring a rigidity to the same, even if it is pitted against the substantial justice. Stop. We are also not unmindful of the proposition of law that some of the procedural provisions can be held to be mandatory depending upon the nature of the provisions discerned from the language used therein. It is right to mention that the litigation in the country filed before the different courts takes longer time to get it disposed of, and the legislatures were conscious about the consequences that would follow for the events happened during the pendency of such litigations. Precisely for such reasons, Order 22 of the Codicil Procedure was incorporated to save the pending litigations and the avoidance to perish on the death of any of the parties to the proceeding. The first and foremost conditions required for bringing the legal representatives in place and state of the deceased party is that the right to sue survives upon him/them, as the legislatures were conscious that each and every person having no remote, having no nexus or remotest, having no nexus to the cause of the proceeding initiated by a disease, may be brought as a party to embarrass not only to the legal representatives, but the adversary against whom the claim was made. We hasten to add that the several provisions contained under Order 22 of the court is neutral in the sense that it does not restrict the right of the parties, right either of the plaintiff or the defendant to apply for bringing the legal representatives on record under that of the plaintiff or the defendant, as the case may be. Either of the parties to either of the surviving parties to the proceeding, or even a legal representatives can bring an application for bringing the legal representatives on record in place of a deceased party, be it plaintiff or defendant. The object is laudable to the effect that the legislature did not conceive of perishing and or diminishing or defeating the right of the parties who died during the pendency of the proceedings, but to continue with such cause, but to continue with such cause by bringing the legal representatives, provided the right to sue survives. The legislature did not include the word heirs, heir or heirs, in any of the rule within Order 22 of the Code of Civil Procedure, but consciously mention the word within court legal representatives, which with an intent to make it more broader and not to restrict only amongst the heirs recognized under the law of inheritance. The reason for the same can be deciphered from the fact that the code defines legal representatives under section 2 within bracket 11 thereof to mean a person who in law represents the estate, E-S-T-A-T, estate of a deceased person, comma, and includes any person who intermeddles, I-N-T-E-R-M-E-D-D-L-E-S, intermeddles with the estate of the deceased, and where a party sues or is sued in a representative character, the person on whom the estate devolves on the death of a party so suing or sued. The definition of a legal representative is expansive and engulfed within its folds not only the heirs, but a person who intermeddles with the state of the deceased. Stop. Any other restrictive meaning has to be eschewed, as it would be opposed to the legislative intent. Next paragraph. The question often arises: who would be regarded as a legal representatives? In relation to an estate of a deceased. And if any such issues are raised, the legislatures have taken care of by incorporating Order 22, Rule 5 of the court, which confers power upon the court to determine such questions. Obviously, before the court decided to proceed with the case. There is no ambiguity in our mind that Order 22 is contained an exhaustive provision relating to substitutions. And by virtue of Order 22, Rule 11 of the court, such provision is extendable to the appellate court as well. Full stop. The law is somewhat settled. No, sorry. Order 22, Rule 9 of the court postulates that in the event right to sue survives, and if the application is not taken out within the period of limitation provided for bringing the legal representatives in place and state of the deceased party, it would attract abatement of the suit/appeal, having a resultant effect of the dismissal of the suit, depending upon the nature of the claim, where the court before perceiving that the suit of the appeal is abated, requires a conscious application of mind in conjunction with the relief claimed therein. Stop. In the event the relief cannot be granted in absence of the legal representatives of any of the party to the proceeding, it will invite the abatement of the suit/appeal as a whole. But where the court finds that the relief can be granted in presence of the surviving parties to the suit, and the segregation is permissible, it may only invite an abatement against the deceased. Stop. It is no longer a res integra that in the event the right to sue survives, it would not attract abatement which is apparent from Order 22, Rule 1 of the court, provided the application for bringing the legal representatives are filed within the statutory period of limitation. It is somewhat settled that if some of the legal representatives are already on record, now some of the legal representatives of the deceased party are already on record, it will not attract abatement, as the estate of the deceased party can be sufficiently represented by them. The doctrine of representation is a well-recognized legal concept in judicial parlance, where a person can represent the state as a whole in absence of any legal representatives, provided he acts bona fide to protect the interest, the interest in the state of the deceased, and have not committed any fraud of against the left out legal representatives. The applicability of the doctrine of representation in the judicial system can be seen from a 3-judge bench decision of the Supreme Court, rendered in case of Dayaram and others versus Shamsundari and others, reported in AIR 1965 Supreme Court 1049. The identical question arose therein whether the proceeding would abate in absence of not bringing the entire set of legal representatives and the consequences to follow thereupon. In the said case, upon the death of the party, some of the legal representatives were brought on record at the behest of the surviving party. But later on, it was pointed out that some other legal representatives have been left out and not implemented as party therein. And therefore, it would attract the abatement. The apex court held that Order 22 of the court does not refer the word heir, but consciously use the expression legal representatives, and therefore the concept of heirship and the legal representatives are distinct and separate. Stop. The moment some of the legal representatives are already brought on record, to avoid the penal consequences of abatement of the proceeding. Stop. Comma. The court is not denuded of any power to bring the other legal representatives on record by way of an addition in the following, quote, paragraph 12. Paragraph 11 and 12. Paragraph 11 and 12 are the relevant ones. From the above quoted observations, it is manifest that there is that there is no fetter on the part of the court to bring the other legal representatives on record by way of an addition, which necessarily implies that it is not necessary that the order substituting some of the legal representatives is required to be recalled stop. The reason can be reasonably seen from the above observation that some of the legal representatives who have been brought on record by way of substitution can sufficiently represent the estate of the deceased, and any decision taken in the said proceeding would not only bind them, but the other legal representatives, provided such decisions impinges upon the estate of the deceased and the subject matter is relatable thereto. The apex court was conscious that in order to bring a completeness of the parties in a legal proceeding, it is desirable that the left out legal representative should also be brought on record by way of an addition. But such rule is not inflexible, as in deserving cases, more particularly when the court does not find that the state of the deceased is not properly represented by the legal representatives already on record, to proceed with the hearing of the said proceeding and decide the same. The reason is obvious that bringing the left out legal representatives may at times delay the disposal of the proceedings, as in case of a defendant/respondent, a fresh summon is required to be served upon them, and they may be permitted to defend the said proceeding. The aforesaid principles have been restated and reiterated in a subsequent decision of the Supreme Court in case of Varada Rajan versus Kanakavali and others, reported in AIR 2000 Supreme Court, page 740.
2020.
740.
You know, that says 2000.
2020.
Yes.
Supreme Court.
Yes, yes, yes.
Page 740.
Yes, yes.
2020. I have said something wrong.
I had 2000.
2000. I do not. 2020 Supreme Court, page 740.
Hmm?
The apex court held that bringing the legal representatives in a suit or an appeal is for the purpose of such litigation more particularly to represent the state of a disease, so that the decision may bind the state in the following, bole paragraph 9 and 10. এটাকে কোট করে দাও। দেখো, the cumulative effect of the aforesaid, the cumulative effect of the ratio laid down by the apex court in the above mentioned judgments, in the above mentioned reports, is explicit that the court is not denuded of power to allow the implement of a left out legal representatives even at the stage of the final hearing, in order to bring completeness of the parties in the legal proceedings. And above all, the parties to be bound by any decision taken therein. It further propagates the doctrine of representation, where some of the legal representatives brought on record can sufficiently represent the state of the deceased party, and the suit would not abate nor fail in absence of the other legal representatives, provided the legal representatives on record defends the right of the deceased and protects the estate left by him. Stop. There is also no impediment on the part of the court to add the left out legal representatives as party to the proceedings. And therefore, it is not necessary that the order substituting some of the legal representatives in place and state of the deceased party, or in the event some of the legal representatives who are already on record at the time of the death of one of the party to the proceeding. কি বলেছি? That it is ঠিক আছে, comma is required to be recalled before the court it starts its journey on the terrain of addition of party. Full stop. We thus do not find that it is that the order by which the application being CAN 7393 of 2018 was allowed is required to be recalled before proceeding with the hearing of an application being CAN 8 of 2022. let the sorry, full stop. Liberty is granted to the parties to mention the said application before the appropriate page. Anything is left out?
No.
Any more thing is required to be brought?
No, question of appellate, because your lordship has said it is not required to be recalled. Therefore, the jurisdiction of the appellate side is not required to be said. ওই বইটা রেখেছে, বইটা লিখবে, কোট করবে।
এই বইটা আমাদের এসছে 20 AIR 2020 যেটা পাঠিয়েছিলেন, বইগুলো রাখো না, বই সবসময় ফেরত দিয়ে দাও, আমাদের বইটা আনাও। What disposed of? কোনো ডিসপোজাল নেই, এটা ডিসপোজড অফ নয়। Let's call the next.
Lord, my lords can leave to. Lord, what very urgent order for promoter may be taken up tomorrow, Lord Gali. Very urgent.
Yes, tomorrow.
Lord, I'm giving
More difficult.
giving the party.
Give everything tomorrow.
Oh, Lord, will not see it tomorrow. Lord, very urgent. That's why
Go before the other bench. It will be assigned.
there is no other alternative.
My lord, I appear for the respondent, my lord.
Yes, who is for?
Lord, I am for the appeal.
You are served. Now you are ready with the main matter.
My lord, the merits, my lord, most of the documents and my lord not on record. No stay application has been filed, my lord.
Not
I am
required.
only armed, my lord, with the plain in the case, my lord, and the
It is
give the
not
impunity.
required because this appeal arises from.
My lord, a dismissal order of the suit. The plaintiff's suit has been
No,
dismissed.
no. There is a delay. There is a delay of 358 days. So we have to consider first the question of limitation.
On the last occasion, your lordship was pleased to hold that the matter will be taken up.
If we find a merit, then we will allow, otherwise we will defeat. Now, tell us.
Ground number 2 and 3 are vital.
First, tell us what is the matter about, what is the fact, what is
Fact is
involved.
this, my lord,
I do not find
for
the
cancellation of a deed
judgment. I
which
do
was
not find.
which was fraudulently taken.
Judgment is, my lord.
No, I did not find a judgment here.
My lord, it possibly is with the memo of appeal, my lord. The my lord,
Memo of appeal, you have included only one page. This suit is coming up for declaration. Of course, this suit coming on this day for final disposal in presence of such and such. Schedule of the property ordered that the instant suit is dismissed. Where is the finding? This is a degree only given. Where is the judgment?
Judgment on a judgment.
Judgment আছে?
Expert here to fix the
No, আমার কাছে judgment নেই।
Expertise order, expertise.
Yes, yes, that I find. But I do, oh yes, I got it. Don't. Akshay, can you give me 2 minutes time? Just hurriedly go through this.
Yes, my lord. In short, my lord, the case, my lord, has already produced the order.
Are you supporting the concept of law which has been laid down in the impugned judgments?
My lord, from the impugned judgment, my lord, 3 exhibits the plaintiff has exhibited.
Have you seen the concept of law?
My lord, the plaintiff has to prove his case of title, my lord.
He has not, he has defeated on another ground. What is a suit for, sir?
My lord, for
The
my lord,
suit
challenging
for-
the gift deed, my lord.
Deed of gift. According to him, it was never executed in the garb of the power of attorney.
My lord.
Your client got this deed of gift executed. They produced they said that they went to the office, registry office, and obtained the certified copy. And that is the starting point of the knowledge.
My lord.
They produced the certified copy. It was marked exhibit.
My lord.
But the court has said that since the deed of gift is not proved properly because you did not call for a attesting witness. Look, he is challenging, saying, I never executed deed of gift. Wanted to challenge that deed of gift. He has to prove a deed of gift by bringing the attesting witness.
My lord, in my humble submission, my lord,
Can
the
it be a law?
execution-
Tell us one judgment. I am ready to accept that.
My lord, the only, my lord, proposition, my lord, the only argument that I have, my lord, the execution of a document is not challenged. Now, what document is being executed, my lord? What document is being executed, my lord? They must adduce some evidence to show
Correct.
what document.
But the court has a corresponding duty
My lord.
to record the finding on the evidence which he adduced.
My lord.
Is it not a corresponding duty that what he has said? The court simply said that since the deed of gift is not proved in accordance with the law, because the attesting witness did not come, so he has failed to prove his case. Can it be? Can it apply in a case of this nature where he is saying that he never executed deed of gift?
My lord.
It is a void one.
My lord.
Then how he has to prove
My lord,
the deed?
My lord, in the impugned judgment, my lord, humble submission, my lord, in the impugned judgment, my lord, the finding of the learned trial court, my lord, is that the fraud that is alleged in the plaint, by the plaintiff
Yes.
has not also been proved. My lord,
What?
their entire case is, my lord, premised on fraud being perpetrated. instead of-
How one can prove a fraud?
My lord, for that evidence needs to be analyzed. My lord,
Correct.
let the
His
affidavit.
his case is very simple.
My lord,
His case is very simple.
my lord. My lord, that, my lord, my lord, the affidavit in chief, my lord, that
So,
was
so
tendered.
you are,
My lord,
you are agreeing that this portion is not correct.
my lord, as
That he has to prove the deed of gift by bringing the attesting witness when he is unaware of anything.
possibly, my lord, subject to correction, my lord, the attesting witness could have, my lord, given evidence as to what occurred at the time of
How
execution.
he will bring him? He does not know any person.
My lord,
He says that some documents got it executed by you.
my lord,
How
that-
he know?
my lord, may I make one submission as well, my lord? My lord, I'm carrying the impugned deed of gift with me. My lord, it is not his case. He cannot today contend that it was executed behind his back because, my lord, it was executed presented for execution at the registry office, my lord.
Correct.
This is not a case for commission.
He is also not denying.
My lord,
Please, two things. Execution is not denied.
no, my lord,
Registration is also not denied.
my lord,
But the nature of the document, there is a dispute.
my lord.
According to him, it was a power of attorney which he wanted to execute, and you got it converted into a deed of gift. So nature,
My lord,
then why the court will say that the deed has to be proved when he produced the certified copy and he adduced evidence in support thereof? Secondly, why not the doctrine of non-traverse will apply? He has alleged the fraud. He has said that this is a fraudulent act.
my lord.
Then in that event, you have not denied.
My lord, I have filed my written statement, my lord, and my lord, in order
But
8,
it
rule
went
10.
ex parte, sir. You
My
did
lord.
not adduce any evidence. Suppose if no evidence is adduced in support of the pleading, will the court go on the pleading, which is not
My
proved?
lord, this has been, my lord, I'm not carrying the judgment today, my lord, but under order 8, rule 10, my lord, the phrases the court may decide in case the defendant does not appear on the fixed
Sir,
date.
it is not a case of order 8 rule 10.
This is-
Order 8 rule 10 when applies, if the written statement is not filed within the time indicated under order 8 rule 1,
My lord,
then the plaintiff can apply for a judgment,
my lord,
and then he need not have to give an evidence also.
my lord,
What are you
But
talking about?
it
He
is-
has not taken shelter under order 8 rule 10.
my lord,
He rather went ahead and wanted to adduce evidence.
my lord. It is not my case, my lord, that he did not adduce evidence. He adduced
So
evidence, my
the
lord.
order 8
However, my
rule
lord,
10 does not like order 37, summary procedures, judgment immediately. Look at order 8 rule 10, sir.
My
Let me read.
my lord, no, order 8 rule 10, my lord. I
Let
was
me read,
mistaken, my
sir.
lord. Order 9, I possibly, my lord, on the date of appearance, if I do not appear, my lord, that I will just look into that rule, my lord. On the date of appearance, if I do not appear as a defendant, my lord, the suit may still proceed and, my lord, be decided in accordance with law, my lord.
Correct.
Even so, my lord, the plaintiff's burden to discharge
True.
his case, my lord,
No doubt.
is not, my lord,
No
the trial
doubt.
court, my lord, in my humble submission, my lord, also holds that he has failed to prove any case of fraud.
Now,
How is fraud, my lord?
question is that he has pleaded it and he must have. Where is your PW1 evidence? Show us.
But this is not before, my lord. At least the evidence in chief should have been, my lord, produced before this honorable court.
Not
My lord,
in chief. It is the only evidence.
my lord, my lord,
You did not appear.
my lord,
So question of cross-examination does not arise.
Lord, I'm not. My client has been unable to provide me with this document, my lord. If, my lord, I can just,
You are not there in picture.
Lord, may I just have a copy? My
Okay,
lord, a
extra
senior friend
copy-
can give me a copy. Well, just to
extra copy নেই কিন্তু
আমি
What more one can do? He has clearly, and the LTI, he has taken a plea that this LTI has not been corroborated. There is no certificate which says that it was read over and explained to him in that language. Nothing of that kind was there. He has said in the evidence. Sir, then what? And it was not a signature, it was an LTI.
My
Then
lord,
there
may I
are
just
certain
consider-
requirements.
My lord,
Sir,
my
have
lord,
you brought those judgments?
let me just consider this and come back tomorrow, my lord. If it commences tomorrow, let me, my lord, consider this. I do not have this copy, my lord.
Be from 1920, if I am not wrong, 20. On the other day, I have delivered one judgment which is also cited, where I have indicated that in case of an LTI, what are the requirements?
I do not have that at this time.
Do you know that judgment? Mr. Harudan Banerjee appeared in that matter. Now, there are right from 1925 Calcutta or so, if I correctly remember. I have quoted those judgments there. But that judgment, nowadays I do not remember the name. No. That is, I have delivered a judgment. If I correctly remember, Mr. Harudan Banerjee, that what are the requirements of law in relation to a illiterate lady and a Pardanasi lady? And there they read over, explained, certificate, those are much required. Even in evidence, it has to be. I held so. You should bring, sir.
I will take it out. I will find it out.
My lord, will grant 1 day's time, my lord. Let me consider this, my lord.
Who
I am
appeared?
handicapped, my lord. I do not have any
That's not
copy.
reported. Must be reported. Because I say reportable. Can anybody get hold of Mr. Haradun Banerjee, because he knows that name of the party?
May I get the name of the parties, my lord?
I do not remember. I just remember the the ratio or the law which has been let down therein, but I don't know the party's name.
Even who was the advocate?
Mr. Haradun Banerjee, I said, he argued.
Or I will talk to him. I will talk to him.
You just talk to him. Fine, if you can get him. We are coming back with
My lord, may I just indicate one fact, my lord? My lord, will kindly take that affidavit in chief, my lord. My lord, will kindly see paragraph 10. My lord, only one fact, my lord. My lord. My lord, this is not a case where this was only an LTI. It was also a case where this deed was signed, and my lord, I'm carrying the deed with me, my lord. All the fingers, my lord.
Where?
My lord, will kindly see paragraph 10.
Yes.
My lord, the fourth line from the bottom. He signed, third line from the bottom, my lord. He signed it bona fide and gave his LTI. He signed it, and my lord, I'm carrying the deed with me. My lord, he is signed in the right places in Bengali, my lord. The deed is in Bengali, my lord. His case is that he had poor eyesight, my lord. His case is he had poor eyesight. He was deceived. My lord, I am also carrying the plaint, my lord. This is not his case as per the plaint. His case in the plaint is that it was signed and changed. The deed was changed subsequently. My lord, this was
he has said that he did not know the content of that.
my lord.
And look, if the evidence goes unchallenged,
My lord, I am trying to only establish.
in absence of any, the cross-examination, as you did not
My
contest,
lord,
then why not the doctrine of non-traverse will apply?
my lord, I bow down, my lord.
So
In that regard, my lord, I had two submissions, my lord. Number one, my lord, I cited the wrong provision, my lord. Order 9, Rule 6 will govern this case, my lord.
Order 9 Rule 6
lord,
talks
procedure-
about where the summon
No, my lord.
has not been accepted, and the court directs the fresh summons to be filed within a time frame, and having not done, then in that event it will go.
My lord.
It is not a case of such nature, sir.
May I just place
Please
order
read Order 9 Rule 6.
My lord, subject to correction, my lord, where the plaintiff appears and the defendant does not appear when the suit is called on for hearing. This is the
Correct.
case in my case.
Correct.
Then A, when the summons is duly served, if it is proved that the summons were duly served, the court may make an order that the suit be heard ex parte.
Correct.
This is, my lord, what
Is
has
what is
happened
the
in this
case
case.
here?
This is what has
Correct.
happened, my lord. That hearing has, my lord, subsequently taken
No,
place,
that's
my lord.
true, no doubt.
My lord. There, my lord, I am carrying one judgment of the Honorable Supreme Court, my lord, that does not discharge the plaintiff's burden.
No,
Now, my lord, I am
who is
showing-
disputing?
My lord.
You are absolutely correct. Even if it is an ex parte,
My lord.
it is a duty of the plaintiff to prove his case.
My lord.
How he will prove the case of fraud? Kindly visualize.
My lord.
He has narrated the incident that which may lead to a fraud.
My lord.
And this statement goes uncontroverted.
My lord, may I?
How the fraud? Tell me in what manner a fraud can be proved. Show me, but tell me how one can prove a fraud.
My lord, we must go by the Contract Act, my lord, section 17,
Please.
the definition of.
How?
My lord.
How? It's the particulars of fraud which is required to be pleaded,
My lord.
which he says. What is the act of fraud? Fraud is that he is a septuagenarian,
My lord.
having a very low eyesight.
My lord.
He does not know anything. He reposed confidence on you because you were the neighbor. Every time he used to go to you. And thereafter, in order to protect his interest, he wanted to give a power attorney to you.
My lord.
And then in the garb of such power attorney, you got the deed of gift executed. Now, if that is the stand taken by him, yes, it is also a case of a fraud. Definitely an element of fraud.
My lord, in this regard,
How the fraud is defined under the Contract Act?
my lord, section 7.
How it is defined?
My lord, there must be either, my lord, may I place section?
Please, what is a fraud? Tell us.
My lord, section 17, my lord, I am placing.
Please read that.
Fraud means and includes any of the following acts committed by a party to a contract.
Correct.
Or with his connivance or by his agent, my lord, will not be the case.
No, this is or his connivance. This is
Or his
also very
connivance.
important.
Connivance.
Yes.
With the intent to deceive another party.
Correct.
There too.
This is what he says.
Hello.
Want to deceive because he wanted to eat up his property. Deceive.
My lord, for that, my lord, the subsections, my lord, will have to be.
Please
those elements,
read
my lord.
that.
The suggestion as a fact of which that is not true
Hmm.
by one who does not believe it to be true.
Correct. That is what he says, that he does not believe that the deed of gift is to be executed.
My lord.
And you, according to him, you were also aware that it's not a deed of gift to be executed. It is a power attorney which is to be executed, and you deceit him.
My lord, for that deceived, my lord, he must show that the
How?
executant at the time, my lord, that, my lord, is an
How he will
inconsistency.
prove? Tell me how he will prove. If he pleads such a fact, how he will prove? Tell me.
My lord, here, my lord, he must then establish, my lord, his
How?
case is that
I
he
am
is getting
asking you,
wrong.
sir,
Fine.
as a student of law, please tell me that what evidence you would require in this regard. Tell us. I am ready to accept. What according to you should be said? What according to you should be produced by him in the nature of such allegation?
My lord, his case is premised solely on one fact, that the executant at the time could not read properly and could not sign his name, and could not read or write properly. That is his case, my lord.
Right.
In that regard, my lord, only his one statement in the evidence in chief is his entire case. And as regards his age, my lord, we'll note paragraph 8, at the time of his death, he was 70. So, my lord, in my humble submission, my lord, he must also prove that he could not read. My lord, I am also carrying the registered deed of gift. My lord will note the pictures are annexed to the deed of gift. It shows that he is wearing spectacles, my lord. If he had trouble reading, my lord, he's wearing spectacles. He was in the registry office at the time of presentation, my lord. So if, my lord, it can be shown from their own evidence, these two, my lord, the evidence in chief as well as the exhibit are both his evidence, my lord.
Correct.
There is an inconsistency in the evidence. My lord, that is my case. There is an inconsistency as to the capability of the executant
Correct.
to understand the meaning and purport of the document.
Correct.
If, my lord, an executant comes to the registry office, understands the purport of the document,
Understand. This is
My lord,
what is
understand.
the, please.
my lord,
He has said that I do not.
my lord,
In paragraph 8, he says that he had also a poor eyesight
poor
and
eyesight.
has no power to read and write. He has said so, which goes unchallenged. He says he has no power to read and write. He could only sign his name. This is an evidence if it goes unchallenged and proved. How one can prove? And he is no longer in the world.
As on that date, my lord, this evidence, apart from a bald government as to his capability, because, my lord,
Thus,
reading or writing, that is his,
that
Yes,
is what
Lord.
is.
that is what is, my lord, if at all, my lord, let it, my lord, go back to trial, my lord, let him prove by whatever
Definitely,
substantiate his allegations, my lord.
the suit has to be, this judgment has to go, and then it will go back.
Lord, let
If
that
you want, I do not know if the summons
will
have
also
been
accept,
served.
my
If
lord.
the summons have been
I will have
served,
to take out applications, my lord, if I am given an opportunity, because I have a written
I do
statement.
not know.
My lord, my
If
lord.
the summon has been served,
My lord.
it is up to the court whether he will accept your written statement
lord,
after
my lord.
such a long time.
My lord, my lord,
We will not make any comment thereupon.
my lord. My lord, will then, it would be my humble prayer, my lord.
This is an application for condonation of delay in preferring the instant appeal. So it is a word in the instant application that the appellant,
আমারই ভুল হয়েছে আমার একটা এক্সট্রা করে নিলে ভালো করতে
could not contact the learned advocate because of his old age and suffering from several illness,
তোমার মক্কেলের আমি একটা
and
জিনিস
was
তোমাকে
not
দেখাচ্ছি
aware of the fact that the suit has been dismissed ex parte on 24th March 2027.
আমি দেখাচ্ছি না ওগুলো কোথায় রাখলাম রে বাবা
After hearing that the appeal has been dismissed, the suit has been dismissed, the contact was made to the advocate, confirms the said fact, and then an application for certified copy was made, and after getting the certified copy and engaging the lawyer to file the instant appeal, there is a delay, a considerable delay. Stop. Considering the aforesaid facts, and upon perusal of the impugned judgments, comma, we find that the meritorious matter should not be defeated on the anvil of the limitation. If the cause shown in the said application is somewhat constitute the sufficient constitute the sufficient is somewhat constitute the sufficiency of the cause, the minor lapses cannot be projected upfront to defeat the meritorious proceeding. The application for condonation of delay is hereby allowed. The delay in filing the instant appeal is hereby condoned. The appeal shall be formally registered in the docket of the court. Since the respondent has also appeared, we invited the counsels appearing for the respective parties to address us on the merit of the instant appeal. Next slide. The appellant filed a suit for declaration that the purported deed number 1537 dated 26/3/2010 is void, having obtained by practicing fraud upon the appellant, by taking an advantage of his poor eyesight and lack of understanding. Stop. It is further averred in the plaint that there was a cordial relation with the defendant, cordial relation of the appellant with the defendant, and in fact he intended to execute a power of attorney so that his right in the property can be protected and taken care of. But taking advantage of the same, the defendant respondent got the deed of gift executed in her favor. Stop. The next one. Admittedly, after service of the summons, the defendant respondent did not appear and contest the said suit, and as a consequence whereof the suit was posted for ex parte hearing. The trial, next paragraph, the trial court dismissed the said suit on 2 counts. Firstly, the plaintiff appellant failed to prove the allegation of fraud in preparing the purported deed of gift. And secondly, the appellant failed to prove the purported deed of gift by bringing the attesting witness. Stop. Stop. It is no doubt true that it is imperative on the part of the plaintiff appellant to prove the case made out in the plaint, even the suit reach the stage, reach the ex parte stage, has reached the stage of ex parte. In normal circumstances, the deed of gift which requires an attestation is to be proved by calling an attesting witness under section 68 of the Evidence Act. Yes, under section 68 of the Evidence Act. The aforesaid provisions postulates that a document which requires an attestation shall not be used as evidence until one attesting witness at least has been called for the purpose of proving its execution. What is required under the aforesaid provisions is that an attesting witness is required for the purpose of proving the execution of the document which is required to be attested under the law. However, the aforesaid provision cannot be pressed in service where the execution of the said document is not denied. Stop. In the instant case, the plaintiff appellant has categorically averred in the plaint that he intended to execute the document by giving a power of attorney to the defendant respondent, but the said defendant respondent, taking advantage of the incapacity, they're taking advantage of the medical condition of the plaintiff appellant, got the purported deed of gift executed in her favor. There is no denial of an execution, and therefore section 68 of the Evidence Act cannot be pressed in service, as it is restricted to a case where the execution is required to be proved of a document. Duly attested by the attesting party witnesses. The case is founded upon an allegation that the defendant respondent has committed fraud upon the plaintiff appellant in converting the power of attorney into a purported deed of gift,
and therefore the suit was filed for declaration of such deed to be declared as void. For such reason, we do not find that the finding of the trial court that the purported deed of gift has not been proved is tenable and or sustainable in law. More particularly, the execution thereof has not been denied by the plaintiff appellant. The core issue involved in the suit is whether the purported deed of gift was obtained by practicing frauds or making misrepresentation. To him. In the affidavit as to examination in chief, the first witness of the plaintiff categorically averred that the said executant had a poor eyesight and was not capable to read and write, though he can sign only. The said witness further deposed that the said executed reposed trust upon the defendant respondent, and in fact intended to execute a power of attorney, but taking advantage of the aforesaid confidence reposed upon the defendant respondent, he was taken to a registry office and surreptitiously got the purported deed of gift executed. The evidence would further reveal that the said executed all along cultivated the said plot, the suit plot, and never parted with possession thereof to the defendant respondent. As indicated above, the suit was tried at the ex parte stage, and therefore the pleading as well as the evidence adduced by the plaintiff appellant remain uncontroverted. Full stop. The court did not consider the other aspect that in order to complete the gift, the transfer must be made voluntarily and without consideration in favor of another, and the same is accepted by the other or anybody on his or on his/her behalf. Section 122 of the Transfer of Property Act further indicates that such acceptance may be made either during the lifetime of the donor or even thereafter, while he is still alive and capable of giving, still alive, Corona, while he is still capable of giving. What is sine qua non to complete the transfer by way of gift is the acceptance by the donee. And in a case of this nature, such acceptance can be presumed in the event the possession of the property involved therein is given to the donee. So the witness of the plaintiff categorically said that categorically deposed about the elements of fraud. And therefore, we fail to understand that what prevailed upon the learned judge in arriving at the conclusion that the plaintiff appellant has failed to prove the allegation of fraud. The order impugned in the instant, in the instant appeal, the judgment and the decree challenge assailed in the instant appeal is hereby set aside. What to do?
My lord, in my humble submission, my lord, there must be
Set
some
aside.
case remand.
Stop. The matter is remitted to the trial court for deciding the said suit afresh.
Obliged to you. My only submission would have been, my lord, their entire case is premised on the eyesight of the test of the my lord, the executant. That is all. That has not been proved.
Obliged to yours.
I would have allowed the suit or the relief. He has not gone into 122 of the transfer of property. His categorical case is that he is still in possession thereof. I have not indicated. He has also filed the porcha and
My lord.
the receipt for payment of tax.
My lord.
I have not said anything that would go against you. Since you said many things, so I venture to say I do not want to make them more wise.
But I am aware those are the
That is the whole problem. Anyhow. Call the next.
But I beg to appear on the plaintiff appellant.
My lord, in this matter, I appear for the respondent, my lord. I have only been served with the copy of the memorandum of appeal. However, no stay application has been served. The covering letter also says only
Not
memorandum of-
required, because unless the appeal is admitted,
Exactly.
The matter
But
part is,
perhaps there is a preliminary point, my lord.
just whatever.
may I just indicate to your lordship?
You are selling which order, sir?
But the order of the appeal court,
Whether the appeal lies.
my lord,
Show
so far
me-
as the impugned order be passed by the,
Sorry, whether appeal lies.
my lord, may kindly see, my lord, it is a suit for declaration and injunction.
I am again asking you, sir. In a suit for declaration injunction, temporary injunction application, whatever the order is passed, you have filed the miscellaneous appeal. And in a miscellaneous appeal, a further application for injunction is filed, whether an appeal lies to the High Court. I am
Yes.
asking.
My lord, so far as the valuation is concerned, my lord, the appeal,
Again, I am saying, forget about the valuation. Whether an appeal lies to the High Court. You have a further right of appeal.
by rejecting an order of injunction, my lord, in my respectful submission, my lord, as per the provisions, codal provision 104,
It says an appeal lies. An appeal lies means only one. Section 104 says no further appeal lies.
the revisable order. Revisable order. May I take back the certified copy and file my paper?
Remedy is which? Which court? Here or up?
227.
After perusing the order impugned in the instant applications and taking into account the report of the stamp reporter, we find that the appellant does not have a remedy of filing an appeal against the impugned order. So the appeal is thus not maintainable, is thus not maintainable. Accordingly, the same is dismissed. However, the dismissal of the appeal shall not prevent the appellant to assail the impugned order before the appropriate forum. The certified copy of the impugned order shall be returned to the advocate and record of the appellant upon replacement with the photocopy thereof by the assistant court officer.
Take on the paper.
Item number 17. My lord, Mr. Hon'ble Chatterjee is appearing as appellant. My lord, he has not come to court till now. My lord, at 2 p.m. he will be coming to court. My lord, can it be taken up at 2 p.m.?
We don't have. I will not be here at 2 p.m.
And then not today, my lord, can take it.
all the time.
No, the 2 p.m. hour.
Why 2 p.m.? Why not here? Anyhow, not today. Though I am here at 2 p.m. Yes, next.
No, no, मामला कोई खुल sir.
Synopsis of the case is that the plaintiff appellant is aggrieved by and dissatisfied with the judgment and order of the civil judge senior division. Short list of date is that 3/1/2023, the judgment and order passed by the learned court in the title suit.
What happened, my lord? I am the plaintiff, my lord.
Who is the advocate and record of the case? Who is Mr. Avirup Haldar? What is expected in the short list of dates and what is expected in the synopsis?
What happened, my lord? I filed, my lord, a partition suit, my lord. In that suit, my
I am
lord,
asking you this, this is one of the form.
it should be detailed.
It appears from the instant case that the synopsis as well as the short list of dates which are required to be appended with the memorandum has been prepared in a most truncated manner, incapable to decipher the facts as well as the events happened in course of the proceeding. The purpose, the object and purpose for introducing the short list of dates and the synopsis to accompany the memorandum of application is to give a broader picture of the the facts involved in the said appeal, which cannot be permitted to be frustrated and or shattered in the manner as is projected before us. There is a strong impression in our mind that since the short list of dates and the synopsis are required to accompany the memorandum of appeal, comma, two pages containing the aforesaid broad heads are sufficient for such compliance, even if it frustrates the very purpose and does not assist the court in having a broader look of the facts involved in the said litigation. Even if we are aware that the Code of Civil Procedure, more particularly Order 41, Rule 1 of the court, does not require the synopsis of the short list of dates to be filed, but the moment the aforesaid requirement is indicated by an administrative order passed by the Chief Justice, comma, the litigant has to follow. Stop. We would not have observed had it been a solitary case, but we notice since past that it has become a routine manner, as every matter contains a synopsis from which no reasonable and prudent man can decipher or understand the facts involved in this said case. We therefore direct the advocate on record of the appellant to file a supplementary synopsis and or the short list of dates within a week from date. Let's list the matter on next Thursday. Let's call the next matter. Key. Sorry, I have another bench.
For the respondent. And for the respondent.
Appeal allowed হয়েছে?
The second appeal is dismissed with no order as to cost. Consequently, can 1 and can 2 are also thus dismissed.
Urgent photo state copy, Lordship.
Yes, call the next.
I am for the appeal. For the appellant.
The instant appeal stand dismissed, no order as to cost. Consequently, application being can 1 of 2003 is also stand dismissed.
এই একটা সকালবেলা মেনশনিং করছিল না ওনার সঙ্গে আমাদের একটা ম্যাটারে কোনটা না 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 হ্যাঁ না না ও নয় ওটা তো অন্য ম্যাটার বলছিল যে ওটা লিস্টে আসেনি বা সামথিং একটা করছিল আমাদের জন্য বললো যে আছে আমার তো মনে নেই কিছু এটা তো দুটোই ছিল
কেস নাম্বার
কেস নম্বর বলছিল তো দেখো আমি দেখলাম একটা আমার কাছে আছে ডিক্টেট করা অর্ডার ওপেন কোর্টে হয়ে গেছে শুধু সই করার জন্য পড়ে আছে আজকে জানি
Lord, I appear on behalf of the
We have
petitioner.
forgotten everything. It was kept somewhere else. Come and argue.
His appeal, we had taken the point of maintainability, that the appeal is not maintainable. Order passed under section 36 subsection 2 of the Arbitration Act. Stay of the award, that is not an appealable order under section 37 of the Arbitration Act.
Forgot.
But this was the
Lord,
point. I remember the
Come
point.
and we'll argue, my lord. I'm being led by Mr. Joy Shah, my lord. He had argued this appeal before your lordships. Lords will kindly keep it at any day convenient. Lords, I'll take, lord,
Let this matter be listed on third.
third.
Be taken up at 2 p.m.
Lords, lords, may it be on the 6th, lords, subject to your
first.
lordships. On
1st October.
1st October. 1st October. Grateful,
First
grateful.
of October is a Sunday.
Huh?
We'll sit on Sunday. Don't worry. Come on first.
Third.
Come on
Third.
first.
Sir, first is Sunday.
First, judge.
No, we can sit.
No,
We
my lord.
sat.
Your
Even we
lordship will
sat
please sit,
on
my lord.
Saturday. We
Let's-
sat on Sunday. Don't worry.
Lords,
We
kindly.
have done the cases.
Lord, may it be on the 2nd, subject to your lordship.
Second of Gandhiji's birthday. Is lost it. তুমি মুখে না শুনে জজ সাহেবকে শোনো।
Lord,
I
6th.
can come on second also.
Lord, 6th.
No difficulty.
Lords, may it be 6th, lords.
Third.
Lord, third, my Mr. Shah won't be there to address you, lordship. Lord, that is the only difficulty, lords. Can it be on the 6th, lords?
Then come
Humble
on fourth.
request.
Fourth.
Fourth I am not there. My lord, fourth I am not there. I mean, cut off.
Lord, Mr.
Sixth, my lord, sixth at 2
Lord,
p.m.
6th, lords, if your lordships kindly.
Come on fifth.
Fifth.
At least the bench succeeded in getting the date.
My lords. I'm grateful.
Fifth. ঠিক আছে, let this matter be listed on. Fifth. এই order করো। Fifth, 2 p.m. This. Which matter?
My lord, this is the matter, my lord. So your lordship had the pleasure of hearing, my lord.
এটা প্রত্যেকদিন কেন বারবার এই ম্যাটার গুলো আসে, অন্য ম্যাটার গুলো যায় না কেন বাবু? হ্যাঁ, প্রত্যেকদিন দেখছি যে এই ম্যাটার গুলো রিপিট হচ্ছে। না তো আগে কি পুরোটা শেষ করে দিয়েছিলাম? জানি না।
My lord, unstamped agreement relied upon injunction passed in the nature of status quo without actually indicating what status quo was all about. There is an application, my lord, for
Where is Kishore Khaitan's case?
carrying it.
2006 volume. All volume I always.
2006, volume 3, SCC 312. Now there's a leap.
Not a status quo. It says
No.
directed
It is
not to
status-
transfer
no,
or alienate.
No. My lord, kindly takes the final order. That's 1/2/2023.
Oh, I am looking at 25 to
Yeah, that was
2021.
the interim order. That interim. This is the final order.
The petition is also filed, certified copy contained the
No,
petition
there's-
also.
this is the problem. When they applied for the certified copy, they got the entire thing in one bunch. I'm a co-share of the property, my lord. I had not been impleted. So, my lord, I've taken out an application for leave to prefer the appeal. I was a co-sharer, my lord.
You
I
were
was
not
the-
a party to the
No,
proceeding.
no. So I've taken out an application for leave to prefer an appeal.
Where is that application?
My lord, that application, my
Has
lord,
not been allowed.
no, not as it allowed, my lord. That's can one. This is, my lord, can one. Yes, please, please, please. Where is that application?
You are one of the co-sharers.
One co-sharers.
What is the suit for?
Suit for specific purposes of contract.
Contract entered into between?
The other co-sharer and a third party. This suit is the instance of a third party.
Which for the other side?
Look, my learned friend appears for the other
respondent.
other co-sharers. my lord.
Yeah.
Supporting him,
Supporting this
opposing you,
after service.
plaintiff?
After service. On the last occasion, we had handed over affidavit service. My lord.
You are not disputing that he is one of the co-sharer.
No, my lord, in my written statement also I have mentioned that the
Why
parties-
you entered into an agreement?
Yes, my lord.
Why you entered into an agreement?
My lord, I dispute that. We did not enter into any agreement. That was completely done out of means of false and malpractice. We, at the time when the particular agreement was executed, I was admitted at the hospital. My operation was going on.
Who are you? Which respondent?
No, they are the respondents number. It should be two and it should be 2 and 3. Tomor Kundu happens to respond in plaintiff. It should be respondent 1.
No. You are Sitaram or
Taram
Pradeep?
Salampuria and Pradeep Salampuria.
Both.
Both.
Who was admitted? An operation was going on. You said then who out of these two person who was admitted and
My lord,
operation was going on that day?
Pradeep Kumar Salampuria. Pradeep Kumar Salampuria.
You have the documents? You have the documents?
Yes, my lord. There is this application, my lord, which we have filed for appropriate orders, my lord. Kindly takes up that application. The discharge certificate, as I see, is at page 25. And in fact, my lord, in the written objection, they have, my lord, made out a case that even the stamp paper of
And
50 rupees.
Sorry. Just one minute. He was admitted in a nursing home on 6/1 and discharged on 10/1. And what is the date of the agreement?
8 January.
8/1, 2018.
Correct.
In fact, my lord, in the written objection, they have also taken up this plea, my lord. Paragraph 7, they said that the defendant lost the concerned stamp paper of 50 having reader such and such, which both the signature of defendant number 2, Pradeep Kumar Salampuri, and defendant number 1.
You were discharged in the midnight.
No, no.
2:30 PM. 2:30 PM.
It looks like AM, but it's PM.
PM.
Looks like, my lord, but
Oh,
it's like,
the hospital.
The medical
discharges you
practitioner's
in the
handwriting
midnight.
pilot
my
knows.
lord, my lord, the reason why I say, my lord, kindly sees the admission, the discharge, and the handwriting. They write AM in a different way. It's like a star, and the PM is a little different, my lord. So I would presume that's PM.
P is written, your name is written there in a different font. P
No, that the piece, that the word starts with P.
is a capital, it's a
Yes,
capital
yes,
one.
yes, yes.
So it's also a capital one.
That certificate received by such and such 10-1. That should be PM, my lord.
AM. AM.
No, no, no. AM. Confusion. Hmm.
What? This is an application for temporary injunction which you have annexed at page 16. 16 of your application, can 2.
Yes. This is not my application number, it's the application of the plaintiff.
Where is the page 2?
Page 2 nahi hai. No, this is the certified copy we received, my lord.
Page, I do not know, at page 16 of the can 2.
Yes. And thereafter, my lord,
17, look at it.
একটা page missing আছে। আশা বলছে একটা page missing আছে। দেখবি তো। Where's certified copy? নিশ্চয়ই মেমোর সাথে certified copy আছে। না, দেখতে ছটফট করিস না, ছটফট করিস না। Is there a part of the certified copy? This application of injunction? My lord, the certified copy, my lord, bears this page number 2.
He did not raise a plea of stamped
not
unregistered
there.
document.
I was not there.
No. Allowed on contest. Oh, you were not
I was
there.
not there. And most importantly, my lord, kindly seize the plane.
Or it summary file. I have never come across a discharge certificate like this. I never come across. And in Bakuda, there is no nursing home. You have to come to this nursing home in Howrah. This is also, you could come to Calcutta. I can understand. Howrah, that too, this nursing home. And Bakuda does not have any nursing home.
আমাদের discharge one.
না এখানে বলছে ওপেন কি আমি পড়তে পারছি না ওপেন ক্যালিওস got already done under it was done not on 8 it was done on 6.
Any other document regarding medical?
Well, this is not my document. This is what they annexed in the written objection.
What he says that it was done on 8. No, it was done on 6.
No, he was admitted on 6th and discharged on 10th.
Not so simple.
No, the certificate.
Look at certificate. Look at the name of the doctor.
Dr.
R.P. Mishra.
R.P. Mishra.
No. R. Kachru.
Doctor. Yes.
And then below that, what has been done? Open, I could not get that. That is done, I believe.
It's probably
Under on 6/1.
operated upon on 6/1 at 8 a.m.
Not operated upon. Operated upon, I do not get it.
No, my lord. The first is probably OP. that after this
No, that is
through
open. That is the word.
open cholecystectomy.
I don't know.
It's probably a gallbladder.
Cystomy.
Probably gallbladder.
Not done. Such and such.
Done
6-1.
On
At
6/1
8
at 8 a.m. So
Correct.
he's admitted on
6 a.m.
6 a.m.
8 a.m.
8 a.m. is the OT.
But he says on 8-1, he says that.
My lord, 8-1, the particular agreement was executed. I said that. He was admitted on 6.
Now, who is the certifying doctor at the right hand side?
RB Mishra,
Where? Consultant.
NSH Medical College and Hospital.
So, and you are
NSH.
where you have been admitted? Where you have been admitted?
This is Bengal Nursing Home.
So, he does not say that he is from Bengal.
If my lord may allow me, my lord, he was admitted. He was the patient under this particular surgeon, and the surgeon referred him to be admitted in a particular nursing home where he has some goodwill and all that. But in that case, he was admitted on the reference of the Dr. RB Mishra. He was in Bengal nursing home. Accordingly, the RB Mishra came there and done the operation. It was on the recommendation of the RB Mishra's recommendation. He was admitted in that particular nursing home.
Oh, then why the name of RP Mishra will come in the discharge certificate? He was a recommending doctor. Then the first column after address, referred doctor, the name of RP Mishra must come.
No, the referred doctor's name is blank.
That's why I say that there RP Mishra should come because he referred.
But
to Dr. Kachru.
Dr. Kachru probably,
And
my lord, subject
Dr.
to correction.
Kachru must sign on a discharge.
Maybe the
certificate.
RMO at that present time when the discharge was done. Maybe Dr. Kachru subject to correction, my lord. He might be the RMO, the receiving medical officer, who is there in the emergency or at the time of the discharge.
No. And I am really surprised that a person who has referred, he will put his signature in the discharge certificate. And he is not attached to this nursing home also. He is a consultant for medical and surgical.
NCH.
I do not know what is this. In NCH Medical College and Hospital. He is not attached to Bengal.
The instruction that I have received, my lord, is that he was under
And how
like a private
sign? Why he will sign on a discharge certificate? He's not supposed. The attending doctor at medical nursing home, a Bengal nursing home will sign. That raises a dispute.
Is the plaint. The suit maintainable. Can an injunction be granted on this unstamped
Suit is
document?
maintainable.
Yes, till the time. No, not even that. Kindly takes the plaint. Kindly takes the plaint.
Correct.
Not
Takes the plate.
unstamped document.
No. It's maintainability when you say suit is maintainable. That's why I'm asking.
No, why I say, Mulot, because the plaint, I say the plaint does not disclose a cause of action. Because the documents relied upon have not been, Mulot, put down in that in a list as mandated under Order 7, Rule 14. Church of Christ. I'm carrying it. The plaint, I said the plaint does not disclose the cause of action in the absence of that document.
then what at best can be done, that he is precluded or debarred from relying on
Relying
those
upon.
docs. That does not mean the suit would fail.
No, my lord, I would have understood had he mentioned that document in the list and appended it to the plaint. I would have understood, my lord. That has not been done. And my lord, at the injunction stage, my lord, learned judge in the court below says, matter of trial.
This is this is an application. Can one seeking leave to file the appeal against the impugned order. Stop. It is stated in the said application that the petitioner, the appellant slash petitioner, slash petitioner is one of the son of late Bishwanath Selampuria, who owned the said property. The property originally belonged to Bishwanath Selampuria, who owned the said property. And after his death, he, along with the respondent number 2 and 3, inherited the aforesaid property. Stop. It is further averred that recently the appellant came to know that his title suit number 33 of 2021 is filed by the respondent number 1 against the respondent number 2 and 3 for a decree of specific performance of a contract allegedly executed by the respondent number 2 and 3 in respect of the aforesaid property. Immediately after coming to know of the same, the applicant made an inquiry, and from there it appears that a impugned order is passed by the trial court directing the parties to maintain status quo with regard to the nature, character, and the possession of the suit premises till the disposal of the suit. It is thus stated that the said order vitally affects his right, which he inherited by way of inheritance, and therefore the appellant petitioner is a person aggrieved. Full stop. The copy of the certified copy of the plaint is also annexed with the memorandum of appeal, wherefrom it appears that a suit for specific performance of an agreement for sale, being title suit number 33 of 2021, is filed by the respondent number 1 against the respondent number 2 and 3, alleging that by virtue of an agreement date of the agreement is not given.
No, that is precisely I was saying that this plaint
By
doesn't
virtue
dispose
of
the cause of action.
of an agreement, the respondent number 2 and 3 express their agreed to sell the said property at a total consideration of rupees 50 lakhs, out of which rupees 20 lakhs have been paid in cash. Stop. It is further
The Baina
alleged, it is further alleged that a Baina Potru was executed on the same day, that is 8/1/2018, when the said amount of earnest money was received in cash. But the aforesaid respondent number 2 and 3 refused to, showed reluctance in executing and registering the deed of sale, despite several requests having been made in this regard, which constrained the respondent number 1 to cause a letter through his lawyer on 19/10/2020, 2020. But despite having received the same, there is no response given by the said respondents, and therefore the plaintiff is entitled to a decree for specific performance of the said Baina Potru. An application for temporary injunction was taken out, and it is not in dispute that an ad interim order of injunction was passed thereupon. Subsequently, the respondent number 2 and 3 appeared and contested the proceeding, alleging that there is that no such Baina Potru was ever executed by them, nor they ever received the alleged amount of rupees 20 lakhs in cash. In fact, the documents in support of the aforesaid stand is also produced was also produced before the trial court. This discharge certificate was produced before the trial court by the said respondents. The trial court proceeded to dispose of the temporary injunction application, directing the parties to maintain status quo in respect of the suit property, with regard to the nature and character as well as the possession thereof. It appears that the trial court was swayed by the fact that that the moment the contesting respondents have taken a stand that the stamp paper was lost from their custody, and probably the plaintiff respondent number 1 has used the same, it raises a vital issue required to be decided at the time of decided at the trial. The trial court, the learned judge, is also of the view that since the contesting respondents have totally denied the allegations made by the plaintiff respondent number 1, it is appropriate and proper to pass an order of temporary injunction. Our attention is further drawn to the schedule of the property appended described in the schedule. Sorry, our also drawn to the description of the property described in the schedule appended to the plans, wherefrom it appears that the entire property has been included therein. The contesting respondent have categorically asserted that the appellant petitioner is one of the heir of the Vishwanath Selampuria, who owned and possessed the scheduled property, and therefore any order pass in respect of the said property has vitally affected the right of the appellant, and therefore the appellant is regarded as a person aggrieved. The application being CN 2023 is allowed. Leave is granted to the appellant to prefer the instant appeal against the impugned order. Now what to do?
Or dispose of the appeal itself.
What to do?
Let the disposes of the appeal and vacates the interim order. It's about notice, my lord. And good, bad, indifferent, my lord, not a scrap of paper in support of the temporary injunction application. No documents relied upon. 714, no cause of action.
Let him come. Give a further notice on them. Let him come. Let us see.
Relax.
May be correct, but let him come.
One indulgence.
From 1st of February 2023, it's a matter of 2 weeks more. If you have suffered this injunction, suffer for 2 weeks more, serve him, come back on 3rd.
An injunction, granted.
I appreciate, but I tell you very frankly, there are certain doubts in both the sides.
Might be.
I'm saying it's better give them another opportunity. We have granted you a deal. Let the appeal along with an application be listed under Order 41, Rule 11 of the Court on 3rd October.
The top 10.
2023. In the meantime, the appellant is directed to serve. Have you served the Can 2?
Everything has been served. Everything has been served.
Can 1 and Can 2
everything
is directed to serve a further notice to the respondent number 1, indicating that this matter would be listed on 3rd October 2021 and shall file 23 and shall file the affidavit service on the return.
The top. At the top.
It will automatically appear.
It will not come. Against this CIS, the other matters will come up above this.
No, it will not. Come. Just remember.
Remind
me. 20.
I'm grateful.
My lord, there was, my lord, I beg to appear on behalf of the appellant. My lord, there was a direction, my lord, upon me, my lord, to use a supplementary affidavit because certain documents, my lord, which are used before the learned court below are, my lord, not annexed to my stay petition. My lord, my lord, could not prepare the supplementary affidavit because of, my lord, some personal reasons. I was not passing through a good phase of life. My lord, may I come
Not
back, my
today.
lord, after a week.
Not today.
Grateful. Grateful.
Automatically 2 weeks.
2 weeks. Wait.
Next.
Great.
May it please your lordship. I beg to appear for the appellant. Your Lord.
Why you beg?
No, my lord, yesterday I have seen your lordship, my lord, and
Why you say?
my lord, I tender my apology, your lordship. My lord, suit for injunction,
Stamp reporter has indicated defect.
defects possibly were cured, my lord.
Cured?
My lord, possibly cured, my lord, I think.
Yes.
Defects. Suit, my,
Yes.
suit for injunction and permanent, suit for declaration and permanent injunction, your lordship, decreed in my favor, my lord.
So decreed.
Decreed.
Yes, sir.
Appeal preferred, my lord. Appeal was
Remand.
remanded. And appeal against an order of remand, your lordship.
Why?
My lord, kindly see page 6 of the judgment imprint, your lordship. Your first paragraph.
He has framed the issue whether the deed of gift is valid.
Valid. The suit decreed on the deed was stood valid. The learned court never disputed with the deed, my lord. No issues was framed. It remained though.
Where is the order? Judgment of the trial court.
My lord, I am giving, my lord, it is not there.
Have you not annexed?
No, my lord, it was not there, but subsequently we supplied it to the department, your lordship. Here is a copy of the judgment.
No. Did you file it in the department?
Without filing the department.
Where is that filing number?
Here it is, my lord.
Where is the filing number?
Filing number is right now with
Title appeal টা পাচ্ছি এখানে।
filing number.
Oh, subsequently you have filed. No, I got it. Don't. Just take your seat for 2 minutes. Yes. You are a defendant or plaintiff?
I'm the plaintiff number one, Your Lordship. I'm the plaintiff, Your Lordship.
Why are you challenging the order of the appellate court?
My lord, only. My lord,
Means the appellate court has given you an opportunity. You
My
have
lord,
not
yes.
proved the deed which is required under the law.
My lord, very well. My lord, when we will appear with the land or trial court? My lord, I agree with your lordship. Police, I've got an opportunity, Your Lordship. The date, kindly extended the date of appearance before the land trial court, Your Lordship. That's the only prayer I make before your lordship.
Rather, the appellate court has saved you.
I've saved me, Your Lordship. No,
Otherwise, the deed of gift could not have been looked into.
section 60, section 60 is a bar, Your
Here is because you have not brought the attesting witness, and the defendant were denying the execution.
They have a category they've denied also.
Correct. That's why then you will have to call the attesting witness. This is what the appellate court has given you a opportunity.
A new life I have got, Your Lordship. A new life.
There's a new phase of life. You wanted the expeditious disposal.
Expedited in the trial court, Your Lordship.
6 months.
Very well. Well, at least I will have the opportunity to give suggestive issues before the landed court below, but that much.
No. All the issues have gone in your favor.
Yes. Only section 60.
Only the issue was the deed of gift, the validity. They said that it was never executed. If you prove it, then the entire ownership upon them to dislodge it. So you first prove it. That is a new lease of life, I must say, given by
New
the
life.
appellate
Yes,
court.
my lord.
You can call the attesting witness and prove it.
That is still alive, my lord.
My learned friend said earlier, my lord, tried to, my lord, obtain an adjournment on the ground that the 10th appeal will be heard. My lord, nothing has progressed on that front. It's time, my lord, that your lordship's orders are, my lord, ultimately given effect.
Yes.
I don't, and maybe Miller, I missed the matter that day. I don't remember us requesting. But in any case, Miller, kindly take the report of the special officer filed on the last day.
Yes.
Lord, paragraph 6. Upon entering the factory premises, the special officer found that portions of the factory shed shown in the sketch map annexed to the previous report of the special officer dated 1st August 2023 have been dismantled. Photographs of the area from where the structures have been dismantled subsequent to the last visit of the special officer have been taken under the instructions of the special officer, and these are, my lord, annexure B. If your lordship is, my lord, please to look at page 9. Lord, it will not show your lordship, my lord, the removal. Page 11, my lord, 12. And my lord, it goes on. Shows the removal. In fact, page 15. Continues, my lord, page 18. And if your lordship is, my lord, please to look at page 18, capital A, that contains a sketch map. And the learned special officer, my lord, has indicated which portions have been dismantled. That's exactly what we had submitted in court, exactly what was disputed by them.
This was never disputed. The bone of contention is the L-shaped portion at the bottom and the legend.
You know, I remember, my lord,
I have decided since last evening that I will not be too overreactive, too interactive. So I just decided to be very calm, quiet, let him be.
if we don't know that we are getting into trouble, it will be problem. That we've dismantled, my lord. Now, my lord, what remains is, if your lordship is pleased to come back to 18A. Now, this area, according to them, is new, which we have made in violation of order, and which, my lord, according to them, is new. There's not a nothing to, my lord, show this. On the other hand, we've shown that this is not new. Your lord, when your lordship was pleased to pass the order on the first occasion, that was on the basis, my lord, of the affidavit where we had admitted 15,000 square feet. We've dismantled over, it was ultimately, my lord, found to be over 16,000. Entire thing has been admitted. But before, my lord, we came to court. Lord, if your lordship is pleased to see the first order. Lord, CC number.
Response to the special officer's report on 1st of August 2020.
This is, my lord, an affidavit dated. It's a response to the report. Backsheet date bolo na. Yes, it is affirmed by Ankit Kejriwal and Ramesh Kumar Kejriwal on 14th August 2023. Lord, please take page 75. This is your lordship's first order.
Page 78, internal page 4. At this stage, it is pointed out that the appellant and the respondent number 5 are further contemplating to make construction over the land of the company. The court finds that the appellant and the respondent number 5 cannot continue with the construction work, as by that time the appeal is disposed of, the position might become irreversible. This court therefore restrains the appellant and the respondent number 5 from making any further construction over the land belonging to Hanuman Cotton Mills Limited in any manner whatsoever till the disposal of the application. This order comes in the wake of an allegation that I was constructing and I was about to dispose of the land as real estate. Your Lordship was pleased to, my Lord, pass an order of injunction so that the position not become irreversible. Subsequently, contempt petition was filed. Then, my Lord, on that fateful day, my Lord, when your Lordship directed demolition, kindly see the reason. Your Lordship's order has reason. It's in this page 41 of this, my Lord, no, page 19, I'm sorry. Page 19 of the same volume, my Lord, order of 3rd February 2023. That at page 20, second paragraph, it has been categorically recorded in the order dated 16 December 2022, based upon the affidavit in opposition filed by the alleged contemners, that they have erected a factory shed allegedly of temporary nature near the blast furnace, covering an area of 15,000 square feet. It was also stated therein that such shed was installed at the same place where a portion of the original shed which had fallen was existing. In view of the categorical admission having been made in the affidavit, I direct the rule to be issued against the contemners. My next, my Lord, please omit the next paragraph. Then my attention is drawn to the report of the special officer and the photographs annexed thereto, indicating that the portion which was apparently a barren land, construction have been made thereon. The moment the violation is imminent and patent on the face of record, it is an ardent duty of the court not only to restore the status quo ante as on the date of passing of the order of injunction, but also to proceed under the Contempt of Court Act, imposing the sentence or penalty as the case may be. Construction made on the teeth of the order of injunction is palpably illegal and cannot be allowed to stand for a moment. An attempt is made on behalf of the alleged contemners in relation to the portion of the area where the construction have been made, the portion shown as vacant. Court does not go into the veracity of the statement. More particularly, when admission has been made in the affidavit for 15,000 square feet. Now, this was your law. It was on admission that I've removed this admission. Doesn't exist anymore. Now, my Lord, I humbly submit that there is, my Lord, no temporary shed also which has been put up after the passing of the order. Nothing there. Now, let me now deal with the finding contained in the first report of the learned special officer. It is not his finding. It is Mr. Bijoli's finding. Please take the first report.
But this order was stayed by the apex court.
Your Lordship had directed demolition. I was unable on that date to say that I'll go and my lord immediately take it off. And your lordship directed demolition. But we went up in a special leave petition. It was stayed. Ultimately, matter was reversed back. That gave us the chance to.
Was, I find at page 44.
Yes.
That it is contended by your counsel, senior counsel, that the impugned order directing the demolition of construction said to have been in violation of the interim order has been passed in a contempt case which is still pending and in which the petitioners are yet to be found and finally found guilty.
Yes.
It is also contended that in the event of the court carrying out the demolition now and eventually finding the petitioners not guilty of contempt, there must be one or more restitution which is not permissible in law.
Yes. So this was the argument made in Supreme Court that
knowing fully well that there was an admission of construction of 15,000.
Yes.
Yes.
Now, that's the Supreme Court argument that maybe your lordship has found, we have admitted, but your lordship has directed demolition. So please stay the demolition. Ultimately, if final punishment is not granted, we may get through. So that my lord, at least that gave us the chance, my lord, to come back and.
So only when the court found him guilty of contempt, then only the court can pass an order of demolition.
I agree with that. But the fact is, what we did achieve that day was that we got that if your lord difficult, it had to go in any case, and it's gone now. But if on that date municipality had gone, my learned friend's client would have ensured that our whole factory would have been ransacked. That is the objective. Objective is not taking out 15,000 square feet shed. How is he concerned? That is not the objective. Objective is to destroy me, destroy my machinery. Those are on, my lord, bank finance. If it's destroyed once, all my molds, etc., are gone once, I'm destroyed. That is the objective. Now, my lord, please, so, my lord, this has been instituted also. Now that, my lord, the construction is not there, I can, my lord, submit this with a little less hesitation. That the petition, my lord, has been filed with oblique motive. The intention behind the petition, my lord, is to cause me prejudice and harm. Why would a person file a contempt petition and prosecute it over weeks? Would I do it to my own property? I would not. Now, please see the stand. May I just take 2 minutes to indicate what the stand of the petitioner is? My lord, first day, 7 o'clock in the evening, stay of a demolition order, my lord, is possible, sir. 3 o'clock. It was a Saturday. We tried our best, my lord, to protect our factory and our machines. Thereafter, we removed the machines and, my lord, we kept it somewhere else next to it and we dismantled it. We needed that time. And we have done what your lordship directed to be done. Now, there are several, my lord, factors in this matter which are important. Number one is motive of the petitioner. Number two, sanctity of this observation that the rare portion is, my lord, construction in breach of order, in violation of order. I'll show your lordship. Number three, what is the evidence on record to show that the rare portion is, my lord, construction in teeth of order? The three, my lord, very important facts. May I, my lord, first indicate to your lordship from the first report that there is nothing on record to show or for the special officers, not the representative, to come to the conclusion. And it was not possible for the special officer to do more. Please take the first report. Where is the evidence? Lord, kindly take the first report. I 13 Lord, I'm sorry, for by first report, I meant the second report, which includes the first report. It's annexed to it. 1st August report. In fact, if your lordship retains the affidavit which I handed up, annexure to that is the 1st August, and that will also have, my lord, my response. In any event, my lord, please see the report. By an order dated 3rd February 23, passed by your lordship, that the undersigned was appointed as special officers to visit the site in question, identify the structures constructed thereon in the teeth of the order of injunction subsequent to the previous report of the special officer dated such and such, and give an appropriate direction to the concerned department to demolish the same within 3 days from the visit of the special officer. Special officer visited the site. Then paragraph 3. On that date, the special officer, with the assistance of, now this is 23, Shondeep Bijoli of Uluberia municipality, had carried out inspection of the new construction portions upon comparing the same with the photographs affixed to the previous report of the special officer. Now, this is very important. On that date, special officer, with the assistance of Shondeep Bijoli of Uluberia municipality, had carried out inspection of the new construction portions upon comparing the same with the photographs affixed to the previous report of the special officer. A rough sketch map was prepared, and while the process of inspection was going on, the special officer was served with an order of the Honorable Supreme Court directing interim suspension of the order of 3rd February. Recording the steps undertaken on that date, the special officer had prepared a report. Copy of report is Annexure A. Now, will you kindly see Annexure A? Now, it's page 14. Yes, page 14. So many. Now, my lord, the first page, my lord, records the history.
Page 14 of what?
Page 15, lord, running. If your lordship is looking at looking at it from my affidavit, then, my lord, the continuous page number is 14.
15.
It's in print, my lord, on the top right-hand column.
What? Yes.
So, my lord, this is where I was reading from. And copy of order, my lord, Annexure A. Then next page is, my lord, the exercise that was carried out. And then the letter is, my lord, 4th February 2023. And in fact, let me read from the second page. Special officer visited the site of the factory. Then, my lord, notice was communicated over phone to the representative of the contemners with a request to be present. Order directed the learned government pleader to arrange for authorized representative of the municipality and officer in charge of the police station to be present. Special officer visited the site at 1 o'clock. The advocate of the contemners handed over a letter informing the special officer that his client had preferred a special leave petition and requested the special officer to refrain from carrying on demolition. Since there was no order of stay, special officer expressed inability and proceeded to commence inspection. It can be found from a plain comparison of the photographs taken by the special officer on 4th February 2023 with the photographs forming part of the previous report of the special officer that there have been constructions made subsequent to the previous visit of the special officer. Special officer has taken photographs of newly constructed shed as well as other building material lying at the space, and copies annexed. Please come to page 24.
Yes.
Lord, page 24, your lordship had, my lord, once, my lord, used the expression that they have, my lord, bulked up. This is, my lord, photograph of that. That's, my lord, gone down. Now, my lord, please see page 26, 27, 28. Your lordship sees page 30, your lordship would see, my lord, and this is, my lord, from the side. 31, my lord, which they were saying is they are making construction, but by then we had already directed that please open it. This is going to happen to you. Then, my lord, these photographs may not continue. Now, Lord, from these photographs, your lordship would not, my lord, come to a conclusion that any portion apart from what has been demolished is, my lord, new construction. Number one. Number two, there is, my lord, no reason for any finding that the rear portion is, my lord, new construction. There is no evidence to that effect. There is, my lord, nothing before your lordship on the basis of which my learned friends, my lord, can persuade your lordship to, my lord, come to the conclusion that the rear portion is new construction. It is not so, which is why, my lord, there is nothing. Now, my lord, please see what goes on. With the assistance of the surveyor, Mr. Shondeep Bijoli, Ulubedia Municipality, and his staff, he could more or less ascertain a newly constructed portion upon comparing the same with the photographs affixed to the previous report of the special officer. This is not the special officer's finding. Mr. Bijoli's finding. He could. Mr. Bijoli has prepared a rough sketch of the newly constructed sheds along with measurements. The said sketch prepared and signed by Mr. Bijoli is affixed herewith and marked with the letter C. Now, my lord, please come to page 35. So, my lord, A, B, C and D are, my lord, 17,000 square feet. All right. একটু তাড়াতাড়ি দেখো খাতাটা বার করো Yeah, I'm just going to compare it with that if your lordship compares it with page 56 of the same affidavit, my lord, Milord, may I hand up a separate copy? It is, Milord, easier to compare. আমাকে একটা copy দাও।
দরকার নেই, দরকার নেই।
So, Milord, this sketch map is prepared. Now, there is, Milord, এটাকে কি বলছে এখানে? Not unauthorized. এটা পুরনো। Milord, right at the top, Milord, please see the top. Top is, Milord, at page 35. Top is, Milord, shaded. Top is shaded. This, Milord, portion, the main part here, Milord, is also shaded. So, Milord, it's not considered to be unauthorized construction, Milord, new construction. That is the difference between, Milord, page 35 and page 56. Now, this is the, now I have two submissions to make. First, Milord, is this. Your Lordship comes back to page 16. This is, Milord, Mr. Bijoli's finding. For contempt, Milord, to lie, for me to go to jail. It will be your Lordship's finding. Your Lordship, Milord, I would have also, Milord, submitted that if special officer goes and renders a finding without any reasons, that can't be relied upon. The petitioner's work, Milord, to come and give your Lordship the proof. Because contempt is a quasi criminal proceeding. Standard of proof is very high, like a criminal matter. So special officer's finding would also not suffice. But I would have been in embarrassment, Milord, to say that. The special officer is somebody who is above board completely. But special officer has not come to a conclusion. Special officer asked Mr. Bijoli to recollect, to look at the photographs. Milord, this sentence, Milord, with the assistance of the surveyor, Mr. Bijoli, Uluberia municipality and his staff, he could more or less ascertain newly constructed portion. The ascertainment is by the municipality, Mr. Bijoli. And it's an ascertainment without reasons. This is, Milord, I would have understood whoever, Milord, makes this ascertainment, he says that, number one, see this picture of 2013. This, here it is vacant land. And now there is construction. This is the second picture. This shows that between 13 and 8 and now, this construction has been done. Nothing. Mr. Bijoli went and, Milord, more or less ascertained. And that also, Milord, more or less. Then, Milord, dispute and first, after Mr. Bijoli ascertains, he doesn't, Milord, say that the rear portion is, Milord, is new construction after the order. He maintains the portions which we have, Milord, removed. He says that is the new construction. Milord, Lordship is not saying anything today. I am getting unnerved.
Why?
Normally by now,
No, I have decided to be very calm now.
the juniors, Milord, will get very unnerved and disturbed in this way.
Why?
We are used to certain, Milord, 10 years now, we are used to more than that. I cite judgments here, Lordship says, have you read? What was that? I forget the name, Milord. I think Rashmi Metallics. That what Supreme Court has said. That if you keep citing the same judgment, then we are used to that. If your Lordship, Milord, I am
No, no.
sure, my lord, that
No, I have-
your lordship after today will reconsider and
No,
go
I have
back to your old
That
self.
was the yesterday evening I decided to be less interactive, no, non-reactive.
This is very unnerving, I must say, my lord. I am getting very unnerved. I am, my lord, severely scared. I am looking for Mr. Mitro desperately.
I cannot resist it. But my lord, looking at Mr. Chaudhary today, I my lord recall Mr. PC Sen. My lord, he was not ready in a matter. He met me out in the corridor. We were before the division bench of Justice Shamal Kumar Sen. My lord, he said, I'm not ready. I said, we had a conference last night. He said, I've forgotten everything. Then, my lord, he enters the court's room. My lord, we get news that Mr. My lord, the Jewish gentleman, please. My lord, अरे আমাদের ऐसा एक ছিল না ইন্টারনেটে গিয়ে মারা গেল My lord, I forget the name. No.
No, before
My lord, we received information that my lord, the gentleman had passed in England 6 weeks back. I forget he was the
Mr. Meyer,
Elias
Elias
Meyer.
Meyer.
Elias Meyer.
Yes.
6 months ago.
Received information. So my lord, Mr. Sen goes into the courtroom and with full aplomb, he my lord, starts on the history of Mr. Elias Meyer. And my lord, the court is to rise at 12:30. So my lord, he continues with Mr. Elias Meyer and his comparison with Mr. Bhabra.
Yeah.
My lord, that goes on, my lord, till my lord, about my lord, 12:15. Then my lord, the division bench says, Mr. Sen, you have an appeal. You want to move it today or you want to do it some other time? Then he says, show me the impugned order. And he starts reading the impugned order. And then he says, kindly see, my lord, once they show me banana, once they show me plantain, they will not give me my money. He got the order and we sat down. My lord, I my lord, very vividly recall my lord, those moments listening to Mr. Chaudhary.
No, it's not that. No, this is genuine. I'm getting scared. Lordship is not. By now, I would have got series of you have to find out. I have to ask my friends what has happened.
The juniors have a complaint that I am too talkative, too reactive, so I decided not to.
Very unnerving, Millard.
Because I was of the view that at least the junior bar must be groomed because they would lead the bar at one day. But anyway.
I joined Mr. Chaudhary in saying, my lord, we my lord, enjoyed your old my lord persona than your
Yes,
lordship's new persona.
that was better, Millard, if I may say so with humility.
My lord, we are used to my lord, that my lord, Justice Tandon. my
This
lord.
is not welcome.
Calm, quiet, apply my mind to the matter, that's all.
No. And this is, your lordship has been like this from this morning.
Yes. I think everybody will share.
No. I'm certain when I come back tomorrow, it will not be like this.
No,
Very unnerving, Millard. I can't understand when the axe is going to fall on my neck. At least, Millard, your lordship's Millard, previous avatar, one could predict, Millard, with reasonable certainty. Axe is balanced on my neck. Now, final chop. But here I won't be able to understand. Feeling Millard scared. In any event, Millard, I'll come back to page 16. So point number 1 is that ascertainment or assessment is by Mr. Bijoli. Point number 2 is there is no previous evidence referred to. In 2013, there was no sketch map. Yes, there were photographs. But in coming to the conclusions, Millard, there is no photograph also, Millard, referred to. That I'm comparing A with this, B with this. Nothing. This is just, Millard, an ipse dixit of Mr. Bijoli. I can't be hanged because of an ipse dixit of Mr. Bijoli. Then, Millard, disputes arose as to the extent of which such constructions need to be demolished. According to the contemners, the order dated 3rd February 2023 directs the special officer to identify such and such square feet of factory shed as stated and recorded in the order dated 16 December 2022 and demolish the same. On the other hand, Mr. Mahesh Kejriwal, representing the petitioners, was of the view that the purport of the order was to demolish everything that was newly constructed. Please, my lord, see this. Subsequent to the order dated 11 September, rival contentions of the parties have been recorded in the minutes. Not minutes I'm not placing. Their intention is to demolish and destroy everything. Milord, if I may just, Milord, give your lordship in bullet form, Milord, what is the matter? Just 4 points. There was a Milord, family with 2 divisions.
Yes.
This is even more dangerous, Milord. Milord, I'll write it, type it out, and Milord, give it, Milord.
Yes.
Milord, there was a. No, I didn't.
No. The only thing is just to keep so that all these bullet points are being well taken care of at the time of delivery of the judgment. Nothing more than that.
I think I should call my senior. Milord, I'll just explain. My lord's officer is more than competent. There is a family settlement of the Kejriwal family, which involves, my lord, one group is my client, the other group is Mr. Shah's client. There is a document which, my lord, shows that machine division is to go to him, foundry division is to come to me. The document also says that you will own and take responsibility. I forget the exact language. Take responsibility and bear all liability. After the document, my lord,
I could not get that.
I'll just give the exact words.
What? The machine division goes to
Machine division goes to him.
The foundry
Comes to me.
Correct.
Now the operative words are, my lord, foundry work will be looked after. That's, my lord, my client by RKK independently. And he will be owning and accepting all liabilities of the same. Make proper admission before the people if they make MKK responsible, that's him. And vice versa. It says, my lord, machine work with all liabilities will be tackled by MKK. So, my lord, he gets machine, I get foundry. This is foundry. Now, my lord, subsequently, my lord, machine, my lord, whatever he does, he removes, my lord, the machines off the machine division to his other companies. Then he comes and attacks me in this company, which controls, my lord, the foundry. We say that this is a complete family severance. The learned company law board holds that it is, my lord, a temporary severance, mainly for the purpose of father, and that he has no right in foundry. That's, my lord, also there. We have, my lord, filed a section 10F appeal saying it has to be final. You have nothing to do with foundry. I have now, my lord, revived foundry. I've invested money. I've invested 15 years of my life in this. In this situation, my lord, in the 10F appeal, he makes an allegation, I'm going to sell off. There's enormous land over there next to, my lord, the factory. So he says, you're going to make a township or something, sell it off, do XYZ. Your lordship said that don't do anything irreversible, make injunction. Few years later, my lord, business was doing well. So we file an application. I mean, I think so. I'm not sure, my lord. If my memory serves me right, that please allow construction. None of them would know this, my lord. The client's son would know this, but I think so, lordship. I will not indicate whether I'm right or wrong. But in any case, no order is passed, varying my lord's order. And I don't recall whether that application was filed or not. And this is about 2019, 2018, that time. And 10F appeal is there for hearing. Suddenly he files this contempt petition because he's seen these temporary sheds being made. Keeps a tab on this. And he's, my lord, ensured that it's demolished. Now, we accept the fact that this is contrary. We accept the fact that this shouldn't have come up. Our understanding was I can put up a temporary shed, take it down, but I don't want to get into it. Not I've done something, I've taken it off. I'm praying for forgiveness. But the attack continues. He would be happiest if he could make it bare land, end foundry division. That's, my lord, his intention. Be that as it may, my lord, I have indicated that this is his motive. It's filed, my lord, with oblique motive, which was point number 1. Now, point number 2, there is, my lord, no proof at all, no evidence before your lordship, which would show that the rear portion, which, my lord, of which they want demolition, is, my lord, construction after the order. Not a single scrap of paper is there or has been relied upon by the special officer. In fact, there is no finding of the special officer. It is Mr. Bijoli's finding. And it is not possible for the learned special officer. What he saw 6 years ago, it's not possible for him, my lord, to exactly remember. Because he was there in 2013. It's not possible for him to remember more than that, 8 years ago, 10 years ago. It's not possible. Which is why, my lord, we have this report. I'll, my lord, now come back to page 16. That again, my lord, I emphasize with the assistance of Surveyor Bijoli of Uluberia Municipality and his staff, he could more or less ascertain a newly constructed portion upon comparing the same with the photographs, and rough sketch has been prepared. Now, this rough sketch doesn't show the rear portion to be new construction. The offending portion, he has been tabulated with ABCD, and he has come up with that 17,000 square feet, which I have taken off. Now, disputes arose as to the extent to which such constructions need to be demolished. According to the contemners, the order dated 3rd February 23 directs the special officer to identify 15,000 square feet of factory shed as stated and recorded in the order and demolish the same. On the other hand, Mahesh Kejriwal, representing the petitioners, was of the view that the purport of the order was to demolish everything that was newly constructed. At about 3 o'clock, they stopped proceeding with the matter because of the service of the Supreme Court order. Now, my lord, Supreme Court on the second hearing, my lord, sends it back. Now, after the matter comes back, that order is there at page 51. Your lordship saw that and directed, my lord, Mr. Shuman Datta to go back. And then, my lord, comes another report, which is dated, my lord, 1st of August 2023. My lord, please see that report. That's the report. Now, my lord, I will show page 14 and read it with, my lord, page 56. Or page 10 and page 56. Special officer visited site. I am at page 11, my lord. On that date, the special officer, with the assistance of Shondip Bijoli of Uluberia Municipality, carried out inspection. Upon comparing the same with photographs affixed to previous report, rough sketch map was prepared. So that's, my lord, the document which I was showing. Then, my lord, the rest of the history. Paragraph 6, relevant portion of the order. Paragraph 8, when Supreme Court has directed special officer to complete exercise as was ordered by the Honorable High Court at Calcutta on 3rd February 23. the direction on the special officer contained in the order of 3rd February 23 regarding demolishing the new structures within 3 days from identification has been modified, etc. Then Millard, paragraph 8. The Uluberia municipality was notified and Mr. Shondeep Bijoli was present at the site along with Mr. Ashok Kumar Sharkar, head estimator. After considering the report of the special officer prepared on 3rd October, the partial sketch prepared by Mr. Bijoli on 4th February and other measurements recorded in consultation with the special officer, a hand-drawn sketch was prepared by Mr. Bijoli and Mr. Sharkar under the supervision of the special officer. A copy of the sketch map signed by special officer Mr. Sharkar, Mr. Bijoli, indicating the existing structure in terms of the report of October 23 and newly constructed sheds after 2013 has been indicated in the sketch. Sketch map shows exact measurements. And this is Milord Annexure C. Now please, Milord, have a look at Annexure C. Page 56, if my recollection is right. Yes, Milord. Page 56.
Yes.
Now, Milord, this time, Milord, it's mentioned here, sketch map prepared by surveyor and head estimator under supervision of special officer. As per, then Milord, please see this. The shaded portion, as per report of Mr. Special Officer, the Special Officer of 3rd October 2013, showing existing structure. Shaded area. Then structure which do not find place in the photographs annexed to the report of October 2013. Now, my lord, this is blank. This portion at the rear is, my lord, considered to be new. Yes, new. Now compare it, my lord, what I was trying to do earlier. Position at rear, same dimensions are mentioned. My lord, please see 52. Right at the end, my lord, if your lordship sees 52, just above K at page 56. At page 56, just above K is 52. Over here also, there's 52.
Yes.
So, my lord, A, B, C, D is, my lord, new construction. And the rest, my lord, is not new construction. The page 35 shaded portion is not new construction. Why did Mr. Bijoli, my lord, change his mind? I ask myself the question, because what is the material? Material is photographs of 2013. Nobody remembers anything what happened 10 years ago. Nobody is a genius. 2013 photographs and my appreciation of the structure in front of me results in page 35. The same thing results in page 56. But there is a huge difference between 35 and 56, and the reasons have not been explained by Mr. Bijoli. Number one. Number two.
Yes.
That I'm feeling better.
No. You said number one, I said number three.
Yes. This is what I'm used to, Millard. So, Millard, number three. Millard, number four. The special officer has not rendered any finding at all. He has not said he is satisfied. This is not satisfaction of special officer. This is not satisfaction of my, and I'm going to rely on those cases which say, my lord, function of court is not to be delegated. Court's function can never be delegated. But yes, your lordship can direct something, some fact, some, my lord, physical inspection to be done and report it back to your lordship. But the decision is of your lordship. Here, my lord, the decision is of Mr. Bijoli, not even of the special officer. And the decision is contradictory to his earlier decision 3 months ago. And no reasons given at all. And then the special officer endorses the decision without giving any reasons and not recording independent satisfaction. And on top of that, there is no material on the basis of which it can be submitted before your lordship, that your lordship should be satisfied that the rear portion is, my lord, new construction. This, my lord, is the situation. You know, till now we were on a complete back foot. We are aware, my lord, that we have offended your lordship. We have offended the institution by, my lord, doing something which may be perceived to be, my lord, contrary to an order of court. There's an order of court, don't put up a shed. Don't put up anything. Don't put up a shed and later go and say that that's not permanent construction. If you have sense, don't do it. We've done it. We're on a complete back foot. We've removed it. And we pray, my lord, I'm going to cite the cases and your lordship knows them, that if it is not complete willful breach and violation, your lordships will not let us go. It is your lordship's domain. If it is not totally willful, on top of that, there is apology. Here there is apology. Here there is remorse. Here there is, my lord, self-inflicted purging of contempt. So, my lord, I show the cases and will not pray for forgiveness as regards what was done and has now been undone. That's, my lord, one part of the matter. I'll come to that. The other part of the matter is, my lord, this continuous assertion that there is more, and I want, my lord, that to be demolished. It is this, my lord, which, my lord, I am addressing now. My senior has abandoned me, my lord. Nah. Judgment. May I just cite a few authorities, my lord? বইগুলো দাও। Lord, your lordships are kind when it comes to disobedience, unless it is willful and malicious disobedience. That would your lordship now 2003 volume 11 SCC page 1 paragraph 17 Section 2B of the Contempt of Courts Act defines civil contempt, and it means willful disobedience to any judgment, decree, direction, order, writ, or other process of a court. I'm sorry, my lord. This is not at page 12 of the report, paragraph 17. Section Section 2B of the Contempt of Courts Act defines civil contempt, and it means willful disobedience to any judgment, decree, direction, order, writ, or other process of a court, or willful breach of undertaking given to a court. Willful means an act or omission which is done voluntarily and intentionally and with the specific intent to do something that the law forbids, or with the specific intent to fail to do something the law requires to be done. That is to say, with bad purpose, either to disobey or to disregard the law. It signifies a deliberate action done with evil intent or with a bad motive or purpose. Therefore, in order to constitute contempt, the order of the court must be of such a nature which is capable of execution by the person charged in normal circumstances. It should not require any extraordinary effort, nor should be dependent either wholly or in part upon any act or omission of a third party for its compliance. This has to be judged. This goes on. Then into fact. So I'm on this, that if there is no evil intent or bad motive, your lordship may not consider it not to be a contempt. Kindly grant leave to. Yeah.
Broken bench because the Honorable Chief Justice not being here, there was a special broken bench of Justice Sharma Bhattacharya with Justice Mukherjee's. So, but I just it so happened it sat today at 3:30. That was my whole day. I'm truly apologetic for my. After in a contempt matter, especially, there's no one has to be extra. The unfortunate part is that we have not been able to get the appeal progressed because of non-availability but my lord, may I, my lord, try to satisfy my lord, firstly, that the contempt petition, before I come to the willful part and that this is fully barred by limitation. Only contempt of court side the petition থেকে বল করো এটা আমার ব্রিফ এটা Lordship, I am ওই দেওয়া আছে contempt of court দেওয়া আছে তো
Section 20.
Section
judgment
20 of the
Supreme Court, Pallab said.
Section 20, no court shall initiate any proceedings of contempt, either on its own motion or otherwise, after expiry of a period of 1 year from the date on which the contempt is alleged to have been committed. Alleged to have been committed. আমার brief repetition, yes. আমার brief তো well, alleged to have been committed, my lord, here. Firstly, one has to show it is a basic doctrine of pleading that the cause of action as per section 20 has arisen within the last 1 year. Now, here the act of contempt, my lord, is as per their own petition case before the act of contempt, more than 2 years before the petition was filed. Where do they rely upon the accounts? Lordship, petition is silent, but fortunately for me, in the দেখো কোন জায়গায় দেখো in the এয়ারটা বার করো এয়ার এগুলো সব বার করো না এখানে দেখা জিষ্ণু মিশে যাচ্ছে এয়ারটা কোথায় কোথায় বলেছে বলো অ্যাকাউন্টস এর উপর নির্ভর করে বেসড অন অ্যাকাউন্ট Lordship kindly comes to the affidavit in reply filed by the contempt. The petition is lacking, but then
দেখাতে চাইছি।
Your Lordship kindly come to page 13 of the affidavit in reply, man. But this is the affidavit. I'm sorry, but this is the affidavit affirmed on by Mahesh Kejriwal in July 2019. July 2019. লুজ কাগজ দেওয়া আছে ঠিক আছে কি বলেছে বডিতে কি আছে
জুলাই 20 বলছে।
July no 19 July 19 2019
24 July or what?
24th July 2019. She kindly comes to page 13 of the affidavit.
Yes.
The last 7 lines of the page. The allegation of temporary nature of the said shed constructed in violation of the the order are absolutely false, and also inter alia falsified by the audited balance sheets of the contemner for the financial year ended 2015, 31st March and 31st March 2016, filed with the Ministry of Corporate Affairs, forming part of the balance sheets of the contemner number 5 for the said financial years, that during the financial year 14-15, addition of 1,28,000 was made to the factory shed and building by the contempt, and the financial year 15-16, the addition to the factory shed and building was made of rupees 11,49,000, 75,000. Copies of the said balance sheets are enclosed and exchanged. Now, Lordship, may I show this? Lordship kindly comes to the first annexure page. The balance sheet starts at page 24. Oh, sorry, 25. This is the revenue expenditure balance sheet. I don't know whatever they've given. Lordship kindly comes to page 30. That the pages are not very clear, but appears to be page 30 where the schedule 11 is there. Schedule 11.
Tangible assets.
Tangible assets. Lordship, the first entry is gross block as at 1st April 2030. Then is addition. Deduction, adjustment, it is nil. As at 31st of March, it's the same. The addition is 1,72,000 to the gross block. What is important is as at 1st April 2014, the 72,44,000. Addition is 1,28,005. This is what they've mentioned in page 14. 1,28,005 during the financial year 14-15. 128,005.
Where is an addition?
Lordship, the
Oh,
addition.
at the bottom, addition. Yes, I got it.
128,005. Lordship has got it, man. So this is what they've mentioned in page 14 of the affidavit. Now, Lordship, so far as the next figure is concerned, for the financial year 15-16, Lordship, the balance sheet starts at page number to page number to pagination. Lordship, kindly, Lordship, will you also allow me to just take out because our brief which has been supplied doesn't have the pagination. They must be having. তোমাদের 2015 তোমার 1500 আরম্ভ হচ্ছে কোন পেজে? আমি এমনি এখান থেকে ওদের অ্যাফিডেভিট থেকে দেখাই, ওদের অ্যাফিডেভিট থেকে দেখা নিতে হবে। 15-16, it is note 11 to the 15-16 balance sheet.
Page 65.
Well, page 65 here. But you note 11, tangible assets, gross block. The first is freehold, then leasehold, then factory, building and shed. As at 31st March 2015, 73,70,051. Additions during the year 11,75,740. So that is what is there at page 14 of the affidavit in reply. These are the two balance sheets. This affidavit is affirmed on in July 2019. After that, 16-17 has come, 17-18 has come. 18-19 possibly is uploaded after because this is the AGM has to be held by 30th of September. Before that, the accounts have to be passed at that account. But though I am under no obligation, after all, limitation is the petitioner's obligation. But I have then, my reply to my show cause, I have annexed the subsequent audited accounts. One thing I can understand once they put us on notice, I may, but then every accounts I have annexed, Lordship, I will show my Lord. এটা কোথায়?
Reply to show cause of the respondent number 2.
So the respondent number 2's reply to the rule where
It's an affidavit of Ramesh.
we are
affidavit
only-
of Ramesh Kumar Kejriwal.
You are on a point of limitation.
I will go by Dimara. Dimara, I'm home, but I am now, since this is as the contempt, after all, the courts, it's different. It's between the court and the alleged contempt. That's why I've gone one step, and I have on my own disclosed the accounts for all the subsequent years. Lordship kindly takes, and as the Lordship has seen, my this limitation point I did not urge before I first had removed what, as per my law's rule, was prima facie case of contempt. But she kindly takes I have extracted that note 11, page 11 it starts. First is 14-15, page 11, that my lord has seen from their reply. Then 15-16, page 12. Then page 13, which they had, which they could have annexed. That's at page 13. Lordship will see the third under the heading, under tangible assets, the third row. Factory, building and addition nil. If there was, they would have certainly annexed because they were relying upon this. Then Lordship will see page 13. Sorry, there are two page 13s. Then 17-18, next page. Till the date of the petition.
Ends at 13.
Well,
It ends at 13.
but the year is 31st March 2018, Lordship.
Yes. Yes.
Factory building is nil.
Yes.
No addition. Third row, factory building and shed, 85,47,000. Additions during the year, nothing. What we have added is machinery, but no. Machinery, electrical installations we have been doing. That's for the running the plant. I have to, some items get scrapped. So this is the point which I want to press upon my lord, and that the petitioner, if after all, this is a section in the act and that's been interpreted by the courts. So 215, that was an argument once upon a time, but as my lord said, Pallab Seth's case and subsequent cases, the courts have interpreted it to. But of course, to contempt, of course, they may have a right to have it undone, but they file a petition in the regular proceeding, not in contempt jurisdiction. Whether they have a right to get it undone or not, one has a right, may have a right, but then they can't come in contempt. That's my only point. That one can always file a petition in the pending appeal or some other any independent proceeding alleging violation. But what I will submit is that the contempt will not lie. But of course, but before I proceed further on this limitation, I want to satisfy my lord that whatever according to us has been done, we have undone it. And lordship, now we are in the territory of surmise and conjecture. I know the receiver, special officer, I have nothing. I have fullest of respect, fondness for Mr. Shuman Dotto. But it's in the arena of surmise and conjecture. Lordship, that, because especially not only by my reply, I will show from one comes to a quasi-criminal court. The test of proof is very high. One just can't say as far as I remember, this was the situation. That cannot be, especially when in civil law, there should have been some evidence if they had, if it was based on, but some map, some plan. That's something I like to show from the report also, that there is, and beyond this element of conjecture. So that will be the other part of my submission before I go back to my dry point of limitation. Lordship, I'm not liking today, my lord, because Lordship is not saying a word. I'm not used to. Lordship is not saying one word. I'm not liking this at all. I must be candid. Lordship must be very, very upset for some reason. I don't like that. I'm not. Lordship's court, I'm being candid. Since at the end of the day, I can say this, but the matter is, Lord said a word to me. Lordship normally would have grilled me for 15 minutes out of the half an hour. But Lordship not saying a word, I am not liking this. Today's atmosphere. I am not liking today's atmosphere.
Concentrating on that.
Well, Lordship always concentrates. There's no doubt about it. Always concentrates, but also keeps us on our toes all the time. Makes us dancing on our toes. I am not liking this, Lordship, keeping a quiet, solemn face. This is very uncomfortable for me. That's something I must say.
No.
Since it's the end of the day and possibly I won't have any more matter before my lord tomorrow also. So I don't like to see this way too.
No. So may I summarize what has been argued? Just in a bullet point, because otherwise I will lose track of the matter.
Lordship will never lose track. That Lordship will never.
Just bullet points. Mr. Chaudhary, the contempt application is taken out with the oblique motive, having no semblance of evidence in this regard. Second bullet point. It is not expected that a person would remember the state of affairs existed in the year 2013. At the time of inspection in the year 2019. And therefore, the word more or less used in the report submitted by the expression more or less used in the report submitted by the special officer has to be construed in the manner that it does not make out a case of contempt to the hilt. Third, The contempt is a quasi-criminal proceeding and therefore has to be decided on the parameter of the proof beyond reasonable doubt, and the concept of preponderance of probability is not attracted there. Third, the report of the special officer is not an independent opinion of the said officer, but what has been held by the surveyor appointed by him is accepted in toto, and in case there is a doubt, the court should not lean towards punishing a person for contempt. Next, there is a complete disparity between the sketch map prepared in the first meeting within bracket page 35 and a sketch map prepared in the next, not meeting of it, on the next visit, both on the next visit within bracket page 56. Wherefrom it would appear that the portion shown at page 56 was conspicuously absent in the sketch map annexed at page 35. Third,
Response to the report of special officer.
there is no concrete proof produced by the petitioner that the offending portion within bracket page 56 is a new construction on the teeth of the order of injunction, and in case of uncertainty, a person cannot be punished for contempt. Next, the contemners have shown fairness in admitting the construction to the tune of more than 15,000 square feet after the order of the injunction, and the same having been demolished. The court should not proceed to punish the contemner for the same. Third, even if there is a violation of the interim order, such violation has to be considered on the parameters of willfulness and deliberate, and in absence thereof, the court should not proceed to punish for contempt. There must be an element of malice in the act of the contemner within bracket (2003) volume 11 SCC page 1 paragraph 17. Mr. Mitro, takes a plea of limitation under section 20 of the Limitation Act, Contempt of Courts Act. According to him, the contempt application should be filed within 1 year from the date of the alleged act of contempt. Stop. The contempt is basically founded on the balance sheet for the year 2014-15 and 15-16 uploaded in the official website of the Ministry of Corporate Affairs. Is it true? Wherein certain additional amount were invested for construction of a structure, and the contempt having taken out in 2018 is apparently barred by limitations. Second, the special officer have proceeded on surmise and conjectures, and no conclusive opinions has been drawn in relation to a contemptuous act. I believe I have covered every bit of the argument. If I left anything, please tell me.
Sorry, sir.
Yes?
No, my lord, your lordship is covered.
When can I?
I I renew my prayer for give us a chance in the appeal. Give us a chance. Or that's why I renew my prayer. Kindly keep it after the
Your
puja.
lordship has not, my lord, entertained this prayer earlier. There is no reason to entertain it now.
No, but the another lease of life can be given because I will not be available from tomorrow.
My lord, whenever his lordship is available next, my lord, I can't, my lord.
So not before 3rd.
After
Okay,
the
then
third.
kindly keep it after the vacation.
Because
Hopefully,
going to a circuit bench at Andaman.
I see. No, my lord, that's all right.
instead of third, Lordship,
16
kindly keep
days.
it after the vacation. Then
My lord, kindly do not do that. Your lordship has heard the matter. And my lord, progressively heard the matter, my lord, on quite a few, my lord, Thursdays and Fridays.
yeah,
This prayer was made earlier, not
I have no bargaining.
6th October.
6th October. I'm grateful.
ওটা কিন্তু অর্ডারে যাবে না। Let this matter be listed on 6th October to be taken up at 2 or 3.
My lord, 2 p.m. 3 p.m. becomes, my lord, very uncertain, my lord.
No, Friday may be uncertain, but at least the other days there is a certainty in it.
So if your lordship, my lord, finds it convenient to keep it at 2, I would request your lordship to keep it at 2.
It's 2 for further argument.
Grateful to you.